for the sole respondent in this case.
Just
Item number 1.
Yes. I am for the sole respondent in this case, my lord. At the outset, I humbly object to the manner of constitution of this larger bench. Because two of the judges have already disagreed with the view of the earlier division bench. If they will be in the bench, larger bench, so the fate of the case is preordained, my lord. My lord, yesterday evening, your lordship was talking of diocese rule of law. So if the rule of will be violated, if the two judges of the division bench will be member of this bench, the outcome will be preordained. While that cannot be open-minded hearing.
So file an objection
in this case. In this respect.
You can file an objection.
I have filed one objection.
You have filed.
Yeah, already filed.
Are you sure about your objection?
Filed or has filed?
You have filed.
Yes, sir.
Where is that?
It's a preliminary objection. Last.
Filed.
Yes, sir. Already filed. Already filed.
Which there on record?
Yes.
Okay. Clear.
Is at the end. The para 2 of your objection, just read. What is this language you have used? How could you say this? Just see the objection. Para 2 of your objection.
Read it loudly.
Read it loudly.
It is quite unethical and unreasonable that the honorable judges who differ from the earlier view of a division bench have been represented in the larger bench constituted on 17th December 2024 for adjudication of the.
What is unethical about it?
I beg apology for that.
No, we are initiating contempt proceeding against you. Who has filed the affidavit?
This is not.
Not against the petitioner person, against you, the lawyer. We shall initiate contempt. Whether this application has been filed through you,
Yes, ma'am.
this objection. We are initiating contempt proceeding.
My lord,
Yes.
For that,
Sorry.
No, this is directly against the honorable judges.
No, my lord, it's
Indeed.
not.
Unethical. How can you say
It is
that?
not
Unethical.
willfully, I have not done.
No, you have not done willfully. We will see later. We'll see later.
Sir, I am raising one.
Mr. Counsel, let us be respectful to each other. You have taken a ground. We have considered that ground. We are of the view that you have committed contempt of court. Not only the person who has shown the affidavit, but you also, because you are an officer of the court and it has been filed through you. So we are initiating contempt proceeding against the person who has filed the objection, and you to whom
It's not willfully done. That's what beg up.
no, you can take that plea. You can take that plea in your reply. The present full bench has been constituted to consider the question raised by to the question constitute to answer the reference made in the order dated 29/10.
Yes.
29/10/2024. For top. Next. An objection has been filed to against constitution of the present full bench on behalf of the respondent. What is his name?
Manoj
Kumar.
Manoj Kumar
Bal.
Yeah.
Bal. paragraph 2 of the objection, two of the objection reads thus. So stop. What is your name?
Pradeep Bhuiyan. Pradeep Bhuiyan.
The
Pradeep or Pradipta?
Pradeep.
Pradipta Kishore Bhuiyan.
the objection by way of affidavit has been filed through Mr. Pradipto Kumar Bhuiyan, Pradipto Kishore Bhuiyan, who is an advocate practicing in this court. Next, we are of prima facie view that the averment made in paragraph 2 or 3, 2 of the objection, of the preliminary objection, is contemptuous and amounts to criminal contempt of court. Full stop. Let a separate proceeding be registered for initiation of criminal contempt. Let separate case be registered for initiation of criminal court proceeding against Manoj Kumar Bal, the deponent of the affidavit, and Mr. P.K. Bhuiya, learned advocate. What is your... so you accept notice? No. Mr. Bhuiya accepts notice notice on his behalf as also on behalf of Manoj Kumar Bal. So stop. List this matter on yes, on which पूरा quote कर दो from paragraph the contempt matter, criminal contempt matter. Stop. In the meanwhile, the opposite parties slash contenders shall be under obligation to file a so-called reply as to why they should not be held guilty and duly punished for scandalizing this court, for committing criminal contempt of court. Yes. File your reply. Both cases. Next date 15.
Mr. Das, you got some citations?
I've got some citations and note of submission also. I have prepared a small note of submission.
On this also, Mr. Advocate General will appear.
Well,
We request Mr.
will have you.
No, in the contempt matter. We request Mr. Charlan, Advocate General, to assess this court in the criminal contempt matter. Yes.
Right.
maybe pardon to make a mention, but there is batch of petitions in the site may be valid. Where interim orders were passed. In one of such petitions, a intervention petition was filed, and the case was listed under order with this intervention petition along with another IF for appropriate orders. That case was had. The case was never had on merit, and some orders were passed in that interim application. But after 1 week, merit, the order has been uploaded where the case has been dismissed on merit, merit, and the
By this bench.
no, merit, this is a rate of merit.
So you file
Read
a
appeal, you file your slip.
So give
File your slip.
The objective is that, madam, basing on that.
Please file your slips, all the slips. Please give your,
One post is going to fill up.
please give your.
Now, contempt matters here, construction has been stopped because of non-allowing of quarry permission. National Highway stopped. Now, contempt matter, non-contempt.
Give your. All the.
Pardon to mention, my lord, item number 35 of today's supplementary list, my lord. Three identical matters are there. One matter your lordship have kept for on 11th of February. And I have taken consent of my lord senior that other two matters will be fixed on the same day, 11th February. In the meantime,
Which item?
Item 35.
Yes, matter will not be taken up, so there is no strict. These are the similar matters.
55.
Has to be extended.
Yes.
What about the last one?
If the last one, there is no increase. The lordship should consider, I leave it to you. There is no interim order in the last one.
Oh,
First case.
then
Same interim order in the, like in the other cases, if the lordship should consider.
First got that here. So I.
can we
Another
do that?
has no objection.
We can,
Let.
Oh, sorry, I'm so sorry. No, my apologies.
Because the other similar
Yes, ma'am.
cases where the revisional authority said they don't have the power.
Yes.
grateful. Same incident.
So Parija. That case was listed yesterday, it has been adjourned to 11.
Yes, ma'am. That's what.
Whether we can pass exit only.
I mean, the exception. There is listed today. In any case, it is listed today.
Yes.
I'm so sorry.
But it was adjourned to 11. So last time the listed on the day and the other matters are.
I will let you know. Because the other two matters is finished.
Matters under the heading for orders, item number 11.
Section 304E of IPC matter. He has been sentenced to imprisonment for life. And IF of bail of the petitioner minor. For the appellant is in custody for 13 years, 6 months, and 15 days as of today.
What is the? How many times? Rejected once, twice, or 4 times? Remain once. 17. Item 11.
Earlier rejected by which bench?
On, no, I was just. If 17/8, 2020, it has been this time. Thereafter. From paragraph 2, it is threatened to kill her along with the unbody dead. Assaulted with the doctor also. Order is on 17/8/2019. The mistake. Is it there? Order number may not be there in there. But it is there.
2020.
Huh. No, sorry. Let's give it. 17, no. 17/20. Sorry. Before that. 17/8/2020. All these were passed in the missed case. Okay, pre-order. So while rejecting, it was directly to be listed for hearing. So order number 8. So you assaulted the child also. One small girl child and one in the womb.
The child was 3 years back then. At the time of incident, the child was.
No, but why should it not be heard finally?
I have no objection about it. Can be heard finally.
So we can fix a date.
But if it is for the regular bench, I'll be ready. So we'll take time.
Sorry?
Very fair.
Yes, yes.
This matter for. This application has been filed. Number 12. We are not rejecting. Application has been filed for the release of the appellants on bail under section 389 bracketed 1 of the CRPC upon suspension of sentence. Also, the appellants have remained in custody for more than 13 years.
I think that's 6 months.
More
More than
Or-
13 this time.
more than 13 years. So stop. Learned counsel appearing on behalf of appellant submits.
Unappellate.
One appellant.
Husband.
Appellant submits that he shall not press this application if final hearing of the appeal is expedited. So stop.
Right, it will be listed for hearing. But while rejecting.
List this matter tomorrow under the heading to be mentioned for fixing a date of hearing. We'll see.
Item 12.
May please note. This is an application for bail, my lords. There was another application I pending which I don't want to press, mother, but I want to go ahead with this application, my lord. Almost 2015 occurrence. So almost 10 years in custody, my lord. One solicitor eyewitness whose conduct is also not very convincing, my lord. Secondly, one blow on the head. The hospital region, my lord.
Just checking. It has been rejected once.
Once, not pressed once, my lord.
No, 8/10/2020,
Yes, ma'am.
it has been rejected.
Appellant number 2 was released on that day.
Oh, this prayer of
His
this one
prayer
was.
was not pressed. Apparently, both them 34,
So two appellants.
two appellants.
Since
One
no overtact against the other appellant, he was released and this was not pressed.
is- The appellant which was released he was carrying an axe. And this appellant, the present appellant was carrying a crowbar. Sabora that we call in India. So it's a lacerated wound. The hospital result, one wound. That's the postmortem report says it's only one fracture. With some suggestion of previous enmity also was there. The husband is the eyewitness, my lord. He says after seeing the incident, he went away. He hid himself in a place and came back only in the evening.
Which paragraph is that?
PW1.
Medical report. Where?
Medical report is
The learned trial court must have discussed, so where is that? Huh.
After having convicted of the offence punishable under section 302 plus 34 of the IPC, the appellants have been sentenced to undergo imprisonment for life by a judgment dated 19/4/2017 passed by the learned additional session judge Rourkela in ST case number 165 of 2015. Stop. On an application filed on behalf of appellant number 2, he has been
4 and 5.
granted bail upon suspension of sentence during the pendency of the appeal. So stop. The prayer made by appellant number 1 for suspension of sentence was not pressed. So stop. Next. Run counsel appearing on behalf of the appellant has submitted, IE number 4 has submitted that appellant number one has submitted that the appellant number 1 has remained in custody in connection with the said case for more than 10 years.
almost 10 years.
Almost.
6 2015 he was arrested.
13
6 2015.
for more than 9 years. 9 years and 6 months. Stop. She submits that the conviction is based on the evidence of solitary eyewitness,
PW1.
bracketed PW1, and there is evidence of only one blow
One.
on the occipital region.
Occipital. Masseted occipital region. Left ear.
Stop. Next. Be that as it may, on considering the circumstance that the appellant number 1 has remained in custody for more than 9.5 years, and there is no likelihood of this appeal being taken up for final hearing, a case is made out for suspension of sentence and the release of appellant number 1 on bail during the pendency of. Yes.
Thank you.
Item 13.
Justice notice was issued to substituted respondent, except 3D and 7D postal tracking record says notice sufficient and other. So for 3D and 7D are concerned, we have expected a file after asserting the correct address, the repeat. So it will come 2 weeks after.
Which will come 2 weeks after?
Minus,
What will come 2 weeks after?
minus,
No, you said you have filed, it will come 2 weeks after. What will come 2 weeks after? The requisites?
address we put a 3D and the 7D are concerned, we could not get the correct address. It will take time. Day before yesterday we received it and yesterday we have filed the requisites for 3D and 7D.
Yes.
All the other respondents, they have already appealed. The notice has been sufficient. Official directed to issue notice to them so that it will come to us.
And postal requisites and correct address. The basic government permits that postal requisites with correct address have been filed on 7/1/2025. We submit issue notice to the opposite parties to the respondent number 3D and 7D. Say 4 weeks, 6 weeks. Yes.
Item number 14. In my lord, there has been a delay of 89 days. And I pray your lord may grant me longer time for the purpose of substitution because the sole respondent has expired.
It's a bill that when an additional government advocate prays for 1 week time to take step for substitution of respondent number, this is respondent number 1. Lists the case on 27/1/2025. Sorry, not 27/1, 29/1/2025. Yes.
Item 15.
In my lord,
Please share that. I am appearing for respondent 1 and 2. I filed affidavit that the third D and E. I do not want to proceed because both the respondents already engaged in another government service. So they do not want to proceed in this case. So case may be dropped. So in the meanwhile,
Case cannot be dropped because you have an order in your favor which is being challenged by the state. So how can the case be dropped?
in the meanwhile, I have already
We
engaged in another job.
Understood. So case cannot be dropped, but we'll see your affidavit and.
I filed the affidavit.
Yes, yes.
Like D and E.
Yes, yes. Let us.
I am serving the copy to my. Like D and E. Mine.
Set aside the order. 15.
You can withdraw the petition. You can withdraw the writ petition. File an application, we will permit you to withdraw the writ application and the order has been passed. File an application.
Already filed. Mr. Jyotirmay Gupta, learned counsel appearing on behalf of respondent 1 and 2 submits that respondent 1 and 2, I'm not getting the affidavit.
2 members.
1 and 2 both.
Not getting.
2 respondents.
Give me the file if it is there. Got the affidavit. That the respondent 1 and 2 have joined in another government job. Do not have joined in another government job for which they don't want to proceed with this case, for which the proceeding should be dropped. Full stop. In view of the above developments, Mr. Gupta undertakes to file a undertakes to file an IA for withdrawing the writ petition. List the case tomorrow. Yes, for orders.
Day after tomorrow.
Okay,
Yeah.
list the case day after tomorrow for orders along with the IA. Yes.
All right.
Secretary? No. It is Friday, 13th.
Item 16.
All right.
16, my lord, I have to give the cost, it has been given already. Yesterday only.
Yes.
In each account, it has been credited.
Self-check.
Account number is given of that respondent. It has been
Self-check. I'm to enclose here this, your self-check. Has to be check in the name of the respondent, not self-check.
Rinku Sahu.
No, look at your memo. Self-check. Oh, you have done it by account transfer.
Yes, my lord. Yes, my lord. Account
I
transfer.
thought you've given it to Mr. Pradhan. All right. Mr. Bindusar Das, learned additional government advocate, produces the communication of the assistant collector Nizarat dated collectorate Bargad dated 7/1/2025, which requesting the chief manager SBI main branch Bargad to credit rupees 10,000 to the account of Rinku Sahu. Full stop. এটা কোন condemnation of delay that
Yes.
order has been passed.
Yes.
So now what?
Yes, my lord.
What is it? Regularization or what?
Yes,
Is it?
regularization.
So regularization, when have we fixed the matter?
No, actually, as a matter of fact, 15 and 16,
Yes.
both relate to a matter of regularization, taking the help of the judgment rendered by another case, that is Satyavrata Naik, the Honorable Single Judge passed order. Satyavrata Naik has been challenged in a writ appeal where a stay order has been granted. So 15, 16 both relate to that. Now, since a writ
So
appeal
that
has
is pending. This will also
Yes, ma'am.
be decided
Yes.
along with Satyavrata Naik.
Yes.
What is that writ appeal?
Writ appeal number 557 of 2022.
557 of 2022.
22, wherein on 15/9/2022, an interim order,
All right.
stay order has been.
All right. So you accept notice, we'll tag it with the other writ appeal, it can be decided.
The copy of the writ appeal.
Yes.
Writ appeal, my lord, after being rejected by, preferred by state council, state of Orissa, that SLP was filed and that is pending for Honorable Supreme Court. My lord, in the same case, regularization of a data entry operator. I don't know whether this writ appeal they has been granted or not, because it has already been decided by this Honorable Court. And SLP is filed and that is pending for Honorable Supreme Court.
Making a statement.
And how-
That writ appeal 557 of 2022 is pending.
Okay, let us list it along with that, then you produce the orders, it will be better.
Fine.
Yes. Mr. Bimbisar Das, learned additional government advocate, states that what is the WPC? WPC order which has been challenged in writ appeal. 1513. Jagannath Behra. My Jagannath Behra is this case. Acha. Submits that WPC OAC 1513 of 2009 had been disposed of in terms of the judgment dated 15/9/2021 passed in WPC OAC number 902 of 2016, bracketed Satyavrata Naik and others versus State of Odisha. And this order has been challenged by the State of Odisha in writ appeal number 557 of 2022. where the judgment has been stayed by the order dated, impugned judgment has been stayed by order dated 15/9/2022. Hence, list this case for fresh admission along with WPC OSC number 151, sorry, along with WA number 557 of 2000, that day you let us know. 557 of 2022, copy of the appeal memo
Yes, already.
stated to have been served on Mr. S.S. Pradhan, learned counsel appearing on behalf of the respondent. Okay. Okay. So yes. So list the case on 29/1/2025. The same order in the other one. Khali if you cost the IHG, you given us one or second one also same thing.
The second one cost.
Cost?
Cost in the item number 15, there is no question of the cost. In the item 16, cost of 10,000 we have paid.
Okay, then this order which was passed is in the second matter. All right. So first one there is no cost.
No cost.
What 15? This is 16 and 17. Not
No, my
15.
lords. 15 and 16. In 15, I prayed your lordship to grant me 1 week time for removal of defects, and there has been a delay of 104 days. That also relates to Satyavrata Naik.
Just a minute. This order which I dictated is on item 16.
Yes.
All right.
Yes.
So item 15 then Mr. Gupta is appearing. That we have kept to because
he has
that
said
we have
that
yes, that we have kept to Monday.
Yes.
So that is gone. So what are you saying 15, 16? So only 16.
It's only 16.
Yes.
The other one.
Other one has no connection
got-
with this because he wants to withdraw. Yes. All right. Now 17.
Item 17.
The delay of 256 days. This is a case of seal cover procedure adopted by DPC due to vigilance case. Delay of 256 days.
Yes. Delay will issue notice. Issue notice matter of in the matter of condemnation of delay. Yeah, 4 weeks, 6 weeks.
Item 18.
I think delay of 422 days. Case of regularization of DLR.
That we can non-issue. Regularization matters. 27/1.
27/1.
What is your explanation for delay?
Hello?
What is the explanation?
Delay. No explanation. File was moved to the department and delay in letters.
Okay, issue notice on the question of limitation 4 weeks, 6 weeks.
Item 19. 19.
There is a delay of 173 days in filing appeal orders.
Mr. Mahapatra, you are appearing for
I have explained 6 men.
1 to 5, nobody is appearing. Let us see when
1 to 5
what is sufficient. Sorry? Item 9. So 1 to 5 is the department.
No, civil secretary.
Civil Supplies Department.
Yes,
Yes, food and supply. No, there is 2 is project director. So, civil supplies, block development, 4. 2 and 4 are your.
Yes, madam.
So what has happened in this? We had issued notice. Yes.
There is a case where a consumer case was filed. Consumer case was filed. Against that order, a writ application was filed. The honorable single judge has held he is a consumer. So, confirm the order passed by the
Oh, holding that the writ petition is not maintainable,
Yes,
go
yes,
to the writ court.
Applicant is a dealer, my lord. He is no way affected, my lord. I am the beneficiary, the government will give the certain benefit, my lord.
Okay,
He is a dealer, my lord. He has intentionally only to harass the respondent. Please.
Intentionally delayed filing of the writ appeal.
No, my lord. Intentionally after the reach thereafter writ appeal only to harass the.
Why, if the.
Yeah,
We can control the delay and here you
no
are.
affected, my lord. No affected.
See,
Appellant is no.
What is
yes, please make your submissions on merits.
Ma'am,
To condone the delay.
if the consumer district for my lord, I was set expert my lord. But in the order my lord, the direction was given to me to allot the previous commodities my lord.
Who are you?
I am for the dealer my lord. I was set expert for the consumer my lord.
You were set expertise means
My
you did not appear.
my lord.
So you were set expertise.
My direction was given to me to that's why I filed the. So I belongs to the same village of the upper part respondent number 6 my lord. He is creating disturbance and we are asking for PDS commodities my lord. That's why I filed the petition.
Creating disturbance means?
My lord, to approaching for the PDS commodities my lord. But the government is not allotting me my lord. But he is approaching us to distribution of the PDS commodities my lord.
Government is not allotting, he is approaching you.
That quota in respect of the respondent number 6 is not allotted to me, my lord. But he is approaching for the PDS commodities, my lord.
So why writ petition?
And the writ petition on the ground, I have filed the writ petition on the ground that.
No, madam, we have not been able to understand the issue. What is the issue?
I have challenged.
What is the issue?
First you say who are you and who is respondent
dealer, my
6?
lord.
You are the dealer. Who is respondent 6?
As well as the private opponent, the beneficiary, my lord. He is the beneficiary, my lord.
You are saying he is beneficiary, then you are saying government has not allotted. What is the meaning of that?
You were writ petitioner.
My lord.
You were writ petitioner.
Writ petitioner, my lord.
Consumer. The order has been passed by the district consumer or state?
District consumer.
Then why did you not file appeal?
Yes.
My lord, only on the ground I have filed the writ petition that the petitioner, the opposite respondent number 6 is a beneficiary.
Madam, you could have preferred appeal against that order. Why did you file writ petition?
One second, my lord. The respondent number 6 is coming under the National Food Security Act and under the clause of beneficiary, my lord. The Consumer Act is totally different from the National Food Security Act, my lord. There is a grievance redressal forum on the district level for their grievances for the beneficiary, my lord, under the National Food Security Act. My humble submission is this should not go to the consumer and consumer case is not maintainable. Because they are the legislative intent of the consumer is something different from the National Food Security Act also. That is why I have filed in the.
So you thought that because it is not maintainable, you will not appear in that court and come straight to the High Court challenging the order.
I should not come to the web.
That should not mean nothing was
direction
issued to you. You should have
distribute my lords there.
No, you could have assailed the order by filing an appeal. Why did you not do that?
We can understand if it was order of the state commission, you have to go to Delhi, one can understand. Here, what is your problem? Instead of coming to High Court, you would have gone to CDA.
But without the decision,
Not inclined.
can be independent.
We condone. We'll dismiss. Yes.
We are not inclined to interfere because of that. You have alternate efficacious remedy.
That's it.
हाँ क्या बोला? Oh, sorry, alternative. That is the only remedy. Yes. Yeah, what is it? What is the alternative?
Yes, madam, sorry.
Item number 20. 20, my lord. There has been a delay of 207 days in procedural lawsuits state appeal. 207 days delay, my lord. And the
What is the issue you are appealing?
issue, my lord, Honorable Single Judge has considered noting in the file, government file, to be directions. And basing on those directions, the fate of the case has been.
That is what the Supreme Court has recently held, that even notings can be seen.
Seen, my lord. Can those, we have raised a question, can those notings be treated to be orders, directions? That is the point we have taken.
We are condoning it.
What is the physical limit? What is cost?
207 days, my lord.
5,000.
5,000 cost. So list on fresh admission on, so you'll pay the cost within 2 weeks.
My lord.
This is the case on 29/1/2025 for fresh admission.
Item 21.
Appellants challenging order under Article 7 series 7 at case 38, and there is a delay of for 39 days delay. And the explanation to the delay is that though the present appellants were made party in the repetition, but no notice was issued, and on the first day the matter has been disposed of for directing evicting the present appellants.
Where is the order?
Order is at page 38, your Lord. The relevant order is page 41. Order number 1.
Single judge eviction.
After relating to OPLE, for that reason.
Acha, all right.
The repetition filed in guise of PIL, but learned under single judge has disposed of.
No, but just see the operative portion.
Manoj?
Not evict the unauthorized.
Operative person is para 8, your lordship.
One. Previous page, please. Then the petition first paragraph is visible.
And in view of this order, Councillor is issuing notice to evict me without hearing my lord.
Issue notice of the question of limitation. That's 4 weeks, 6 weeks.
May I pray, my lord?
Not now, because your appeal is in
Because there is a limitation, but Councillor is going to evict us, my lord.
Let us see. When did you learn about the order?
My lord,
Have you stated any IA?
on 16/12, there is a beat of drum, my lord.
And before that, you did not have any idea.
On 3/9/2024, notice was received, and we have filed writ application before this before single judge. And there,
Writ application.
before this court, before single judge challenging eviction notice, my lord.
When did you file?
My lord, I have filed immediately after receiving the notice.
So therefore, you can see, stay there.
Because that court state that as because the eviction
We
notice
can-
was issued
No,
in
sorry,
view of
sorry,
direction of
sorry,
decision of the
sorry,
court,
sorry,
hence we
sorry.
go there.
Sorry, not.
They have to
No, but in the notice, was it mentioned that it is subject?
yes, Your Lordship.
What is not heard, yes, what? Was it, in the notice, was it mentioned that it is pursuant to order of this,
Yes, sir.
then what were you doing?
But due
So
to
can another single judge stay order of another single judge?
this is under annexure 4 at page 34, Your Lordship, that is in OEA.
Okay, what is the notice? Notice by which one?
Before the learned single judge.
Yes, Your Lordship.
Then,
But under single judge in subsequent stage stated that as because the eviction order issued in view of direction of this honorable court, single judge, then you go
we
inappropriately.
will see, not now. Without condoning the delay, we cannot pass any interim
I
order.
abandon Your Lordship, but as because of urgency, I am saying before Your Lordship. Because if the actual eviction is will be done, then
See, Mr. Counsel, we cannot become single.
But
I
you,
count on Your Lordship.
but you are encroaching the public road.
No, my lord, that is hatto, my lord. The kisam of the land is hatto, and I am doing business, constructing the, giving rent to the Gram Panchayat, Your Lordship, and the land is given to the Gram Panchayat, Your Lordship. In the remarks column, it is stated that Singla Gram Panchayat द्वारा रक्षणाबेक्षण हुए, managed by Gram Panchayat, and we are giving rent to the Gram Panchayat, Your Lordship.
We will see.
Item number 1. Okay.
Who has filed the review application?
I have filed it.
There is no ground for review.
No, sir, because the restriction remains pending, Your Lordship. The SBI State Bank of India, they had come before this.
No,
Your Lordship.
see, we have to decide the review petition first.
Man, that's what
Thereafter,
I'm-
we can take up contempt matter.
No, that's what I am saying, Your Lordship.
Yes.
Review petition. Because against the interim order, the State Bank of India had come up before the writ appeal court, Your Lordship. Then there the writ appeal court has allowed the almost the prayer in the writ petition in the writ appeal while the writ petition remains pending, Your Lordship. Against that, Your Lordship, the contempt petition will be filed for implementation of that, Your Lordship. I had carried the matter to the Honorable Supreme Court. The Honorable Supreme Court said that since the review is available for you, you go there and have a
There is
review.
the question of review. Review of an interim order.
Interim order, Your Lordship. Interim order, the
You
writ appeal
took
was
that
filed.
liberty.
Right.
You took that liberty and that liberty was given to you.
Well, I
So if the order is interim, the
Yes.
matter is pending, then
Yes.
where is the question of review?
No, review is against the writ appeal order, it's not against the writ petition order. Writ
Writ-
appeal order is also.
And its petition is still
Yes,
pending.
it's still pending, you know.
So come to the grounds which you have taken.
Minus.
So whether any ground is there for review.
Yes.
Come to the grounds which you have taken in your review application. And just point
Yes.
out whether
Yes.
any ground is a valid ground for review.
Your Lordship.
One single ground.
Minus.
One single ground.
Your Lordship. Yeah, Your Lordship, may I just have a request, Your Lordship. Can it be taken up either tomorrow or day after?
Whenever.
Yes.
There is no
tomorrow or day
ground.
after.
See,
Because yesterday I was out of the town, Your Lordship, I have not gone.
Tomorrow.
Tomorrow, day after.
No, can't be day after.
Tomorrow. Yes. Tomorrow. As the first case, Your Lordship.
as requested by.
Copy of review.
Yes, I'll give.
List this as requested by the senior counsel appearing on behalf
In
of
course of the day, I'll send.
the petitioner in RVWPET number 104 of 2022. List this matter on
9th, so 10th.
10th.
Yeah.
10th is Friday. Or 9th. 9th?
9th is tomorrow.
Yes, 9th. 10th is Friday, so we can't take it up, so 9th.
Right, right.
9th.
Copy of the review may also be supplied to the statement.
Yes, you can give. In course of the day.
Item number 2.
Yes, what happened?
The board approved the intercollege transfer. Accordingly, the registrar issued a letter to the principal EIT Autonomous College, Bhubaneswar, to take admission the petitioner. My lord.
How much time will it take?
Miller, in that case, you will also make in that case, I am appearing on behalf of the OP number 4. As per my instruction, which the letter issued from the BPUT University Miller, we received on yesterday. Our responsibility to give her the TC, that is transfer certificate. Whenever she will be available, either on tomorrow or day after tomorrow. Tomorrow is Thursday, that is Lakshmi Day.
Lakshmi Day for TC, what is the problem?
Day after tomorrow.
Yes, don't give.
Gas is not required.
Then what is the problem? Lakshmi Day is a good day. You have any objection for taking TC on Thursday?
Receiving TC on Thursday, that is a Guru Day also.
Very good.
Brihaspati Day.
It is a very good day for her.
Auspicious day for a student. May not be auspicious.
That is up to.
Problem.
So how many?
Mr. Siddhartha Naik must be consulted.
Miller?
You don't file any writ petitions on Thursday?
Thursday.
Even if
Thursday is urgent matter, very urgent
yes,
matter.
this is urgent time.
Urgent.
Today is the 13th day. 13th day when the matter has been taken up. 13th time.
It is auspicious. 13 days also auspicious.
No, 13 is
Mr. Counsel appearing on behalf of
PS
Biju
Naik.
Patnaik University.
Naik.
PS Naik. Biju Patnaik University of Technology, Odisha, Rourkela, has produced before us communication dated 7/1/2025 made by the registrar of the university addressed to the principal/director GITA Autonomous College, Bhubaneswar, regarding the decision of the Circulation Board of Management of the University dated 7/1/2025, allowing petitioners inter-college transfer on medical ground. Full stop. List this matter on 13th within first 5 cases. The court expects that in the meanwhile, the parties shall ensure that the petitioner is given admission in which part? GITA Autonomous.
You will ask me kindly direct the party concerned petition to appear in my college on tomorrow. In the
Mr. Jainal and counsel appearing on behalf of the petitioner undertakes that the petitioner shall appear before the principal.
Director or oblique principal?
Director/principal of which college?
Number 4 college.
Name.
And Synergy Institute of
to obtain transfer certificate.
So, right? Is it decision by circulation or decision of the circulation board? Is there anything like circulation board?
Decision
The board could not be conducted.
I want
by circulation or off circulation, but by of the board. By circulation of the board. We thought there is some circulation board.
that is what I was.
Circulation boards.
Press admission item number 3.
इधर में बता रहे कैसे ये तो सर्कुलेशन बोर्ड ही कैसे है क्या नहीं तो देख हम तो ऑर्डर पे करेक्शन कर रहे कैसे no problem.
Item 3, sir.
Constitution can have a glance to order dated 18/12/2024, the last order.
So what is the delay?
Which order?
Date of order 4.
Carried with the respondent.
No, 18/12. Oh, no, what is that? It will consider the time of admission.
Oh, no one is appearing.
So, what it may I said? Okay.
IA is for what? This IA is for? What is the delay?
200 street.
1 for stay. 204 days delay. 204.
Despite service of notice, no one has entered appearance on behalf of the respondent. So stop. IA number 2828 of 2023. This application has been filed for condonation of delay of 204 days in preferring the appeal. Stop. Considering the facts and circumstances in the interest of justice, the delay in preferring the appeal is condoned, subject to payment of cost of rupees 5,000.
Anyway, 62 years means he's no longer there.
Address, how the notice can be served on this address?
His age 62 years. He could not be living in your office. Unfortunate. Maybe in many cases, notice has been served in similar manner.
Well, we have to collect the
No, not this. Many other cases we have to see.
residential address and we will serve on that.
He may have given that address in the OA because he was working there 10 years back.
So having seen the cause writing, we have said that the appellants have not given the correct address of the respondent, correct residential address of the respondent, Stop.
And we'll take the notice of appraisal.
Let fresh steps be taken for service of notice upon respond number 1 with correct and present address. 4 weeks, 6 weeks.
2 weeks, Lord.
Oh, you file it within.
Within 2 weeks. Within 2 weeks.
Item number 4.
So the petitioners of the Bus Association of Rajgangpur, they have taken the bus as well as bus stand for parking collecting the parking fees. In the during the Corona period, there was no bus was operating. They have demanding that amount, and we are requesting that you deduct that amount, or we are ready to pay. They have given us notice that no, you either pay or you back it, will not renew your agreement. I have given a representation under Annex 5, giving the calculation that after deducting everything, it is coming to 2 lakh something, my lord. And we have deposited to show our bona fide in the year 23, we have deposited 50,000 also. Either, my lord, let them, my lord, accept this amount, and my lord, your lordship consider this, we are ready to deposit this amount. Let them consider this grievance, my lord. But because that period, your lordship knows, every association, every bus, my lord, interest was also waived.
It's a policy matter. They could have taken a decision.
They have
And
not
if
taken a decision on
if
Annex 5.
according to you, the decision is incorrect, because of Corona period, you could not do your business, and therefore you are entitled to something, then you could have filed a suit.
My lord, I
How
have
can
given
we
this
decide?
representation is pending with them.
A
Let them take a decision on that, my lord,
Representation.
because they are not also deciding this money. Neither they are accepting the money, nor they are deciding this. I am ready to, my lord, whatever I have stated, my lord, I am ready to deposit that also.
No, are they demanding?
They have, yes, my lord, they have, your lordship may see last annexure, page 28, annexure 6, they are demanding, my lord, 6 lakhs. 6 lakhs 34,000.
Otherwise,
Otherwise, you back it. I will not renew the agreement.
When the state is opposite, but a copy not served on the state.
Copy had been served, the matter had been dismissed for default, thereafter it has been restored, so. Copy must be there in your record room, I think. Have you served copy initially?
If the OSRTC is Road Transport Corporation, we will take the decision.
Disposal section.
But you serve a copy. It's
I'll
possible they may not be able to trace the.
copy of the
serve it.
after the instruction and council and GA representing the estate of Orissa. List this case on 6 weeks.
Mr. Behra,
Let
Mr. Behra is not, he is for ST.
counter affidavit be filed in the meanwhile. Yes.
Item number 5.
In the meantime, my lord, may I pray, my lord, we'll deposit that amount,
Don't-
whatever we are
Sorry,
claiming.
no, nothing.
Rehabilitation of the matter fixed to 28th of January. All matters.
Item, such. Item 5.
Rehabilitation matter, all the connected matter fixed to 28th of January.
Yes. 20th.
Item number 6.
Here, dependence is some representation case, those have to be brought on record. And may I claim that permitted to withdraw, with liberty to file in place data officer so that everything gets clear. Cases like this, petitioner is a doctor who got the certificate, registered doctor here in Odisha. Thereafter, for further education, he went to Germany. There he obtained the certificate that has been clarified, yes, that is authentic. But they are not registering the post-graduation course here because it has not been provided in the IMC Act of 1956. Now they have
During the pendency, they have rejected the forwarding letter, the representation that has been forwarded by the state medical council to the National Commission. The National Commission has communicated this order during the pendency of this writ application. So instead of filing the amendment, I want to withdraw this with liberty to file a fresh writ application challenging that.
You had filed the writ petition before the Delhi High Court.
Delhi High Court we have filed because Delhi High Court said since you are registered there at Odisha, so jurisdiction is of Orissa High Court.
I have
So we
received the
can-
copy, I have given him the copy of the IMC to OCMR.
He wants.
So he can challenge that.
Yes, that I have already given him the copies.
And counsel appearing on behalf of the petitioner states that certain development has taken place subsequent to filing of the present writ application, in as much as National Medical Commission, New Delhi, has rejected the petitioner's application
Not
for
petitioners, but forwarding the letter of the Odisha Council,
Our register to OCMR.
medical council.
filing the present writ application. In as much as the Postgraduate Medical Education Board, bracketed PGMEB of National Medical Commission, has communicated to the registrar, Odisha Council of Medical Registration, that the internal medicine and cardiology from Medical Association of Lower Saxony, Germany, is not a recognized course as per IMC Act, 1956. So top, he submits that he seeks permission to withdraw the present writ application with a liberty to question the correctness of the said communication of National Medical Commission dated 27/11/2024. So it's appears on the legal
The 1 and 2.
Yeah, 1 and 2. CMR also now I am.
application is, this writ application is accordingly dismissed as withdrawn with the liberty to the petitioner to question the with the liberty to the petitioner as sought for. Yes.
Yes.
Item number 7.
7 is below that same SMEC report, where the orders are so-called reply filed and it says that not satisfied. Similar
Yes,
matter,
why, who
courtships
is
are passed
appearing
before.
for the state? Thank you.
Mr. Panda,
No, no. Not granted similar order in other cases.
Similar order we are passing.
Yes.
Why this is happening in each and every case? This is such a simple thing. You could have said something in your order. Similar.
The Lordship may see paragraph.
Sometimes your officers pass such orders to favor
Paragraph
the,
6, madam.
I don't know.
I'm sorry.
Yes.
Paragraph 6, your Lordships have said. Reach your principles of natural justice. Last 3 lines of the paragraph. The Lordships have said no coercive action in the next. In para 9.
Same thing.
Yes, sir.
Same order, Mr.
The same date may be fixed also 11 February. We will file counters in all cases And maybe my lord, analogous hearing.
Can you,
11.
can
I'll
you
make
suggest?
correction with you. Sorry. Very good. Tell me about it. Yes, sir. Complete.
This one, on which day?
11.
11 good.
This policy was came into force in 24 January 2024. In this policy, there are 7 benefits were given to the Odisha small and micro enterprises. The 7 benefits are EMD exemption, paper cost exemption, past experience exemption.
This has been taken up, this is being taken up for the first time.
Yes. Paper cost exemption and performance security exemption up to 75%. Annual turnover reduced up to 90%. Purchase preference up to 30%. Price preference up to 30% in participation of tender phases. But in this notification, there is a clause in para 3. If any government organization want to formulate the policy difference, they may bring their proposal to government. Then government may decide. And then on 9th February 2024, Managing Director, Odisha State.
Yes, who is appearing for the other side?
Whereas I appear for the state, the imbue notification, the challenge here is basically to the terms of the tender. And the notification whereby the health department has been excluded is at page number 39, 1/3/2024. And that has been done as per the policy, para 3 of the policy. And let's, if I can refer to page number 39, annexure 8A.
Yes.
In exercise of powers conferred under para 3, which is at page number 17 of the Odisha policy, Odisha procurement preference policy. Para 3, my lord, talks about deviation from the policy. And the steps involved, I mentioned in para 3 has been followed, and a proposal was submitted by the department, which was considered by the committee headed by Chief Secretary, and thereafter the decision has been taken. So this notification, and hence few exemptions were not given to the to the MSME because of the important procurement which has to be done in the medical department. That proposal, my lords, is also at page number 29.
You can file a reply.
One more, my lords, if I can draw your attention to the prayer. My lords, page number 10.
Yes.
Here the petitioner therefore prays that your lordship would graciously be pleased to consider the above facts and circumstances and admit the writ application issue notice to the opposite parties. In case the petitioner is qualified in testing reports as required by the tender calling authority, that is opposite party number 5, then while petitioner will not be eligible to avail the benefits of the OSME, so and so. My lord, this imbue notification is not under challenge.
That notification which you were referring to.
Yes, my lord.
Okay, so that notification comes in the way of
Yes, sir.
practicing.
Pursuant to that, the Odisha State Medical Corporation has floated the tender matter. Now, my learned friend, his prayer is, allow me to be there in the Odisha State Medical Corporation tender process without challenging the notification which is published by the MSME department.
Your Lordship, I had required there in tender note in please Lordship see kindly annexure 3.
Already let them, you don't challenge, you're not required to challenge, they will file reply.
What is the stage of the tender?
My lord, I have given to understand this morning that the online technical bids is still open.
So you can proceed with it.
Yes.
Process.
Your Lordship, I have been filed for stay for the notification.
No, we are not granted. Issue notice. To accept notice on behalf of, is it party number?
I'm for office partner 5, Odisha State Medical College.
1 to 4 is, you are for 1 to 4.
Yes.
My left time for 1.
And Mr. Party for copy number 5. No problem. Let's this case on 8 weeks. Stop, let counter affidavits be filed in the meanwhile. Stop, next.
Prayer in your, sorry. No.
We make it clear that the opposite parties shall be at liberty to proceed with the tender process in question, and pendency of the presented application shall not come in way of the concerned opposite parties taking final decision.
Your IA prayer, kindly check it.
Item number 9.
If they be taken up at 2 o'clock, there are some judgments that I will just make copies at 2 o'clock.
What is this?
This dispute is about the laws. My lords, after the 74th amendment to the constitution, my lords, it was this, the constitutional amendment that was brought forth was that all the chairmen of municipality will be elected members. Now, this, my lord, section 53 remains in the statute book from the beginning, my lords. And it still remains, notwithstanding the mandate of the 74th amendment.
So you are challenging virus of
The
section.
virus of section 53, my lords.
Any matter connected with the same dispute.
No, it's
My lords,
there in a certificate.
no, there is a writ appeal. Writ appeal, my lords,
Has no
against.
connection, has no connection with.
No, this, here I'm only challenging the constitutional validity of continuance of section 53, my lords, because
So that.
now the apex court
So that
says.
has no bearing on
No,
that.
that has no bearing. My lords, here we had raised this issue that this provision is to be read down. My lord, the apex court says that there is a difference between selected members and elected members. Elected members are not subservient to the state government or their officials. So the state government officials have no power to remove an elected member. It is the mandate of the people. The constitution decided, I mean the parliament decided that the mandate should flow right down to the basic, my lords, municipalities, to the Gram Panchayat level. Now, the will of the people will be thwarted by just arbitrary actions of the
So
state
according
government,
to
my
you,
lords.
an elected member can not be removed by any process
No, my lords.
other than impeachment.
My lords, there is a different process that other elected members, they can pass a resolution of no confidence. That is there under section 54. But the state government itself, because the apex court says that the state government officials are not, I mean, the elected representative is not subservient. I'll place those judgments. That is why, my lords, and autonomy has to be granted to all the municipalities.
All right. Now, senior counsel appearing on behalf of the petitioner while assailing the constitutional validity of section 53 of, what is that? Odisha Gram Panchayat?
Odisha Municipal Odisha Municipal Act 1951.
1951 has
Sorry,
submitted
50.
that
1950.
submitted that he is required to place certain Supreme Court's decision in support of his case. So, as requested, list this matter. Let it come after 19th.
Yeah, Lordships may hear it. It's an interesting question.
It will be difficult.
Just an admission, my lords.
20th.
Anything.
20th.
Item number 10.
Wish your lordships a very happy new year.
Same to you.
Your lordship. This is the second contempt arising out of matrimonial offense. And the petitioner and the wife prefer matrimonial offense,
Contempt.
challenging the quantum of alimony. Earlier, as per order dated 21st June 2023, under Annexure 1, page 10 में कायली सी.
Page
In
10.
para 5, from middle it has mentioned, order has been passed. The respondent is directed to pay the parental alimony to the extent of 3 lakhs within a period of 4 weeks. As the husband has not been paid, thereafter contempt petition has been filed. That is under Annexure 2. As per order dated 21st September 2023, para 4, let the opposite party comply with the same if not already been complied within in the meantime within a period of 3 months from the date of communication of the certified copy of the order. But till yet, the opposite party with the husband has not complied the order of this honorable court. On the other hand, he has married to another lady. Divorce.
So that is not a
He was
contempt.
decreed.
That is not a contempt.
Now, the husband filed petition, my lord, with affidavit. He was agreed to pay the amount of rupees 3 lakhs with support of affidavit in original matrimonial appeal. But till now, he is played by hiding.
Issue notice. Yes.
The stipulated period has already been over. Second contempt petition has been filed.
All right. We are issuing notice.
My personal appeals to make allegation.
Before, don't know what stand is taken. The response.
For admission item 22.
22. May I please remember? But this is the PIL related to leprosy elimination program in the state university. On 7th May 2024, your lordships are desired to know whether the state has accepted, implemented the NLET program in the state or not. And secondly, your lordships are desired to know whether the state has appointed trained paramedical workers for the purposes, your lordship. My lord, in response to that, the opposite parties have filed an affidavit on dated 17th June 2024, your lordship. There, they have accepted that yes, the state of Orissa is implementing national leprosy elimination program since 1983, your lordship. But to the second question, that whether they have employed paramedical workers, they have taken the stand that it's not required. And my lord, on the day they submitted this affidavit, the responsible secretary SSC TD was there online, and he made a statement that leprosy in this state is far and few. That's why they don't require paramedical work. My lord, on this point, that's why I had to develop a bulky affidavit. Your lordship, who are curious why I have submitted such a bulky affidavit. I seek your lordship's permission for 10 minutes to present the entire case. My lord, the statistics that the opposite parties have presented on that day, they say that leprosy is few and far between, but they quote the data, which is currently 8,396 persons per year are being affected by leprosy, which if calculated, 1% every hour in this state is being affected by leprosy, which by WHO standards is very high and is a public health concern. Now, your lordship, kindly consider, if this is the situation where WHO says that if the prevalence rate is more than 1%, it is a public health concern. On these statistics, which is a very conservative statistics, according to these statistics, it is very high. It is a public health concern. Now, the point is why my opposite, my friends in the government are taking a stand that this is few and far between and paramedical workers are not required. They're saying that it can be done by ASA and other workers. As if ASA and other workers can substitute the paramedical workers, which is not a fact. Your lordship, I have brought on record to my affidavit that National Leprosy Elimination Program visualizes the elimination program
with the trained paramedical workers as a fulcrum of it, and assigned other workers are to support their activities. Your Lordship, in conspectus, the leprosy, as we all know, was a cause, was considered as a cause because it didn't have a cure. In the late 70s, when MDT was developed, invented, there was a chance to cure this particular disease. Your Lordship, there was a cure, not a vaccine. So that required that early, whenever symptoms arise, the patients have to be detected early and to be treated early so that deformities are prevented. My Lord, all over the country, this program was, MDT was introduced, and India declared itself leprosy free. That means a prevalence rate of below 1% in the year 2005. State of Odisha did a magnificent, took a very different approach to eliminate leprosy. While my affidavit filed on 1/9/2023, I brought on record how the state achieved this target of bringing down leprosy below 1 per 10,000% minor. What they did, they didn't actually intervene in the ground. What they did, by order, they stopped active surveillance, they stopped active detection, and they eliminated those who were there, leprosy patients on the list by order. I have annexed those things in my affidavit. By order, they eliminated those leprosy patients, those who were on record, in order to ensure on record that leprosy has actually come down. Your Lordship, that was not the case. Since they eliminated the paramedical workers, there were 1,000 some odd paramedical workers in this state. They eliminated most of the posts, retained only 404 paramedical workers, because it was required that at least because the National Leprosy Elimination Program visualizes integration of leprosy treatment with general healthcare. Therefore, all the leprosy treatment needed to be done from the PSCs, public health system. So therefore, by nominally they just kept one paramedical worker per PSC. That counted to 404, and they eliminated rest of the paramedical workers. Since the paramedical workers were not there, so active detection was not conducted, and leprosy couldn't be treated early. That led to large numbers of deformities. My Lord, in my affidavit at page 65, 66, if your Lordships kindly peruse the data sheet, would show that there is an increase in the MB rate. MB rate means that is while somebody develops deformities. Deformities occur, my Lord.
No, but see, you have brought on record certain new facts. By filing this rejoinder affidavit, you are bringing on record certain new facts which were not there. Those facts might be within the knowledge of the state government, and according to you, they might have concealed that also. We don't know. But whether you have gone through the affidavit, rejoinder.
Lordship, this has come to me for the first time today, Your Lordship. And we have also received minutes of the committee meeting, dated 9/10/2024, Your Lordship. So I take time to file an additional affidavit to the effect of the meeting, what has taken place there, Your Lordship, because district-wise, the collector.
Your stand is clear in paragraph 5.
Yes, Your
According to you, the National Leprosy Eradication Program and General Healthcare System, these have been integrated.
Yes, Your Lordship.
And therefore, according to you, no dedicated paramedical workers are required.
As a matter of policy, Your Lordship.
Yes, Mr. Mishra.
Madam, I have brought on record the guidelines prepared by the Government of India, which is followed in this state, which has to be followed in this state, where the role of paramedical workers and the role of ASA are clearly delineated. Your Lordship, I mean,
see, Mr. You want this court to pass an order against the conscious policy decision of the state government.
My Lord, My humble prayer is that whatever they have actually retained, the number of paramedical workers who are the fulcrum of this program, because without them, two things are not happening. One is that
Sir, please try to understand this, that you want us to frame a policy. If required, we can do that also.
Right.
If they fail and if we are required, we can do that. But there must be some strong foundation.
My lord,
And
that's what
on
I'm-
basis of
I'm drawing your lordship's attention to that. My lord, may I kindly have a look at page number 25 of my affidavit, Your Lordship.
So they have stated whatever steps according to them were required to be taken, have been taken.
That is what is my humble submission, that they are not taking the required steps for which leprosy is increasing. Because they are not taking that. They have retained 404 paramedical worker posts, out of which only 39 are present at present. And your lordship would be astonished to know that budgetary allocation is being made against 404 paramedical workers since 2011, your lordship. And I'm not.
Where is the money going?
That's what is a mystery, your lordship. I'm not, and I do not understand what is the noble idea behind not providing trained paramedical workers, which the esteemed Apex Court had directed to create training centers. Subsequent to that, training centers have been opened, and paramedical workers are given 4 months training to deal with it. My 3 affidavits may kindly be seen by them.
Why should we ignore their statement, paragraph 6?
Kindly not be ignored, but in the context of the matter, the leprosy patients are suffering, and the state's leprosy case is worsening because of this particular.
Come to paragraph 6 of the affidavit.
That is what I started my presentation today with. That what they're saying.
Yes.
What they're saying in paragraph 6 is that this 65,299 detections in the year 1999 and 2000 was due to a massive early detection program with the involvement of thousands of paramedical workers. After that, they consciously took a decision fast to eliminate the paramedical workers in 2002, your lordship. They retained only 400, and after that, they passed order not to go for early detection. They passed an order to eliminate the leprosy patients that are on record in order to achieve on paper that the state of Odisha has reduced leprosy, whereas this was not the fact for which it increased. And from 2010, there have been committee after committee, decision after decision taken, recommendation after recommendation that please bring back paramedical workers. Instead of increasing the number of paramedical workers, the retained 404 even they are not fulfilling, but money is being allocated. Nobody knows where the money is going.
Where have you said?
I have given the budgetary allocations under Annex of 44 series 104 to 1016. I had also given them in my earlier affidavit. Your lordship may kindly see.
Where are you saying that they're taking the funds but not utilizing, taking funds for paying to the paralegal, but they're not, workers are not there? Where have you stated that?
I have stated in all 3 of my affidavits. I'll just bring to my lordship. At page number 9, I have described the 404 paramedical workers are retained on policy as on policy. As per policy.
Which affidavit?
The one I have filed recently, that is on 16/7/2024, your lordship. And at
Page 9.
And my lord, at page 17, 20, on the paragraph 24, I have said that there have been 404 post paramedical, and your lordship, because in Odisha there was an increasing trend of leprosy, central government allocated 184 additional posts of paramedical workers, Your Lordship. This I have mentioned in paragraph 24 at page 17, Your Lordship.
You are seeking a direction from the court to fill up those posts.
At least, at minimum, because that is,
And they are saying that there is no requirement.
but those posts are on according to their own policy. Your Lordship, I'll draw my Lord's attention to one particular document where this 400, in every document prepared by them, it is an agreed fact that 404 at least are retained. Out of that, only 39 are there. So what is happening, Your Lordship, in those colonies in the first place shouldn't have been there under the direction of the esteemed apex court, because those colonies should have been eliminated. There is a law commission report that those colonies who have been staying there should be given the pattas, and the treatment should be done from the general health care system to paramedical workers. So what they are doing, they are not employing the paramedical workers, for which I have given pictures in my here that limbs are being lost, people are not being taken care of, and the case of paramedical leprosy cases are increasing every day, to the extent that today it is in a conservative analysis, because no early detection, because there is no paramedical worker to detect it early.
Maybe.
So for two reasons, at least those paramedical workers are needed to provide care those who are losing limbs and not being able to take care of themselves, and to prevent spread of leprosy and increasing leprosy by detecting early. These are the two purposes for which minimum.
Yes.
Yes.
There is one important issue. If your Lordship can take up IA number 6754 of 2022. This was an intervention application filed by one Bhikari Mahakur. Now, my friend Mr. Mishra, Dr. Mishra Miller, he was not the original counsel in the PIL matters. Mr. B.K. Ragada was there, and at his time, 3 amicus were appointed, me, Mr. Tripathi, and Mrs. Raja. After that, we took whatever we could do, we visited, and we have guided the court. Now, my lord, may kindly see this IA. What my friend is now saying was being said in IA number 6754 of 2022. 6754 of 2020. Yes, if that document can be pulled out, I'm sorry, the document, that is something which is crucial so far as this question is concerned, because unless this is now resolved, because my friend has issues with whatever we are suggesting.
6754.
6754. Now, your Lordship may see the contents of that IA. That was being moved. That was being moved by one Mr. Pankaj Sinha, who is that original proponent in the Supreme Court. He came down here. My friend Mr. Mishra wasn't there at that time. He came down to move this IA. Yes. Now, my lord may see some of the facts in this IA, which are very interesting. Now, specifically, I would show paragraph 14, same cause, that multi-purpose health workers have to come in.
Yes.
Now, Mr. Sinha did move the court. There are orders also recording his appearance, and this was being taken in tandem. Now, somehow this IA, this was being moved along with other developmental work, because the colonies were being visited, collectors were intervening, and Baleswar is one such colony which has seen a turnaround, but other areas need further improvement. They're all there, and pursuant to my friend thereafter appearing on transfer, Mr. Ragada was changed and he appeared. And now, after my friend has appeared, he has issues with us. He says that whatever we have been guiding is incorrect. First, these multi-purpose health workers have to come in, and then this work would go on track.
May I supplement, my lord?
Just a minute.
No, just a minute. So now, this thing, since the last 6 months, this thing is now blocking whatever development can happen. So this has to be resolved. If your lordships agree with what he says, then of course the entire policy of the state government in this PIL has to be overhauled, a new system has to come in, and then we are back on track. If what he is saying, and if he is espousing the cause of the interveners, then my lord, this is something serious. This PIL has now been converted into a, I can say with some amount of responsibility, this is now being converted into a service matter, where these multi-purpose health workers have to be engaged at the instance of the PIL petition. If that can be espoused in this kind of a PIL, then my lords, that's something your lordship have to answer.
Yes.
By virtue of this honorable court direction, my lord, a state level monitoring committee has been constituted. And in the state level monitoring committee, my lord, the health secretary is there and the SSCPD department secretary is also there. He's the convener of the committee, my lord. And me along with Pami Ratho, we are also being appointed by this honorable court to be a part of the monitoring committee. And every 2 months, the committee meets and it looks into that the medical aid, what is being provided to the leprosy affected persons, whether in any district, because all the collectors that participate in that meeting, whether any reconstructive surgery is required at all. And we also look into, my lord, the question of the colonies. What is the standard of the colonies? There's shelter homes, the food, the clothings, there also the MCR shoes, which is a specific shoes for those leprosy affected persons. The committee meets and the last, I think 1 month back, the committee had a meeting.
Mr. Mishra appears to be right in his submission that your emphasis is too much on filling up those 404 posts. And that puts a question on your bona fide also.
May I please?
So apart from that, you can make any submission.
Mind.
If I reject that.
Mind.
May I submit one thing? What he basically is canvassing is appointment, employment of those people. That can be gone into in a service related rate.
May I please?
This cannot be the forum.
May I please? My lord, I am not at all talking about the service.
No, you have
Ma'am.
you have been from the beginning.
Ma'am.
You have been emphasizing on this that
Because-
those 404 posts should be filled up.
Because my lord, without the paramedical workers, I would rather say that the state should employ much more in amount because without
The state will decide.
that, because I have found out that basic requirement that one person per PHC through which the leprosy needs to be treated.
Then they will take care of.
That is not even present. That is the reason for which the emphasis is on that. But apart from that, my humble submission is that the state has to act within the NLP framed by the central government, your lordship. And the central government framed NLP guideline emphasizes a program, eradication program revolving around the services of this
This PIL was filed by whom?
by the persons who have recovered from leprosy and the members of the leprosy association. These are
Bipin Bihari
recovered
Pradhan.
mine.
So that is the.
And you are representing Bipin Bihari Pradhan.
And let my three affidavits may kindly be seen. I am not pushing a cause for the petitioner. My lord, my only submission is that NLP may be implemented in its right perspective as has been envisaged. And out of that, the very fast requirement that comes to my mind because people are suffering and they have made submissions that in Balesur they had to pick up a man who was dying. And your lordship allows me to file an additional affidavit. I have got instruction that the leprosy Hind Kush Nivaran Samiti, of which Excellency, the President is the patron at the national level. Excellency, the Governor is the patron at the state level.
So you are now making unnecessary submissions. Just come to the point.
Only submission that NLP should be implemented in its right perspective as per the guideline. That is what is, and because I am concerned about the plight of the people, and I see that out of the minimum retained position, even out of that only 39 are existing. Naturally, the service is being affected. That's why my little harping on this. If that is too much, then I bow down before your lordship. But that is not my point. Point is leprosy eradication.
That has been your point.
Yes, my lord. Because they have been resisting that particular thing. Why? my question, the question I'm asking myself, what can be the idea? Because that is a requirement, minimum requirement. Why such a, and if your lordship allows.
They also know that.
No,
What is the minimum requirement?
that is what.
They know better than what you know.
Your lordship, recommendation after recommendation, your lordship may kindly, in this particular affidavit, there is recommendation every meeting at every level that please bring in paramedical workers. Your lordship, Annex 43, if all the documents have signed at their level, at the government level, there is, and every expert committee meeting, Annex 38, they talk about paramedical workers requirement. Page 63, they talk about paramedical worker requirement, but somehow they are not employing because people are losing their lives and increasing, leprosy is increasing. That's why is my prayer. And I seek your lordship's liberty to bring in that additional.
What additional?
That they are trying to eliminate this leprosy samiti, of which His Excellency is the patron at the national level, and His Excellency, the Governor, is patron at the state level. My lord, kindly come to page number 99. The reason why they are resisting is very clear in this actually. Actually, there was a meeting between the health ministry and the finance ministry, where the decision was to be taken that more paramedical workers were to be brought in. But impersonating that meeting didn't take place. The finance minister is making a statement that the meeting will be held later. Impersonating that meeting. In the sense, saying that meeting took place, whereas the issue could be discussed, this shall be taken up later. Your lordship, page number 99.
They are receiving funds for these health workers, but there is no information as what has happened.
Just let me report one paragraph. The presented petition in the nature of public interest litigation was earlier taken up on 7/5/2024. When following order was passed. In response to the said order, an affidavit has been filed on behalf of the state of Orissa, wherein it has been stated in paragraph 5 that after integration of National Leprosy Eradication Program, bracketed NLEP, with General Health Care System, no dedicated paramedical workers are required to be engaged under NLEP for leprosy screening and treatment, as this program, along with other programs such as TB, malaria, dengue, maternal health, child health and immunization, etc., were required to be carried out as a part of comprehensive healthcare service delivery system. Full stop. It has been stated that allopathic medical officers, Ayush medical officers, paramedical workers, namely multi-purpose health workers, multi-purpose health supervisors, nursing officers and community health officers, laboratory technicians, ASAs, physiotherapists, and other medical staff deliver services under NLEP. So stop. When counsel appearing on behalf of the petitioner has given much emphasis on filling up 404 posts of, what is the post?
Paramedical workers.
Of
Trained
paramedical workers.
Trained
Paramedical workers. So stop. It is, in our considered view, it is purely a matter of policy, which is to be looked into by the state of Odisha as to whether filling of those posts are required in view of the stand taken in paragraph 6 as noted above. So stop. In the present rate application, the court shall not go into that aspect of the matter. Yes.
My lord, put me a question that where have I written that the budget is allocated?
No, that is over.
Okay. Now, my lord, apart from that, the condition of leprosy in this state, as I have stated, is per hour a person is being affected by leprosy. And that is because the early detection program has been stopped. And
so where early detection program has been stopped, where have you said?
My lord, may kindly turn to my affidavit filed on 1/9/2023.
Yes, what about early detection program, madam?
Page number 18 to 21 in that affidavit. By order, they have stopped it.
Please interruptions, Your Lordship, because we have received a committee meeting dated 9/10/2024, Your Lordship, where all the collector and ADM and all the DSO Puri, from every district, they have informed to the committee as to what steps they have taken. And all.
List this matter on. Please. So stop, let the state inform this court as to what steps have been taken for early detection of leprosy disease in the wake of the submission which has been made on behalf of the petitioner, that because the state has not taken steps for early detection, statistics is not correct. Is this your stand?
No, I'm saying it is conservative because if early detection is not done.
Cases, early detection has been?
Is not done, then obviously the cases will not be reported that much. They will appear only when there is morbidity, when there is deformity. Well, also, kindly look at my affidavit on.
Let them file. Early detection. The statistics prepared by the state of Odisha, available with the state of Odisha, does not depict the correct number of the persons suffering from leprosy. Yes. Let us start from there. Yes.
Please, kindly turn to page number 18 of my past 1/9/2023.
Yes.
Only two pages. Page number 18 of my affidavit. It is a letter issued by the department. The last line, case detection through active case detection method should be immediately stopped. Your Lordship, three lines above that.
So where are you? Where?
I'm saying my affidavit filed on past 1/9/2023. I'm bringing to your Lordship notice their orders.
Yes.
Right. Page number 18, Your Lordship. The last line. Case detection through early case detection method should be immediately stopped. few line, 4 lines above that, 2 points above that, complete cleaning of register operation by a certain day. Your Lordship may kindly turn, whereas the NLEP
Just a
visualization.
minute. Yes, why this decision? Yes, restriction to
Page 18 of the affidavit. And what is the meaning of complete cleaning of register operation?
The instructions, Your Lordship. We'll file a comprehensive affidavit on the early detection, Your Lordship. District wise also.
our attention has been drawn to communication dated 14/7/2003 issued by the Directorate of Health Services, Odisha, addressed to the Chief Medical Officers of Fulbani, Malkangiri, Jagatsinghpur, Gajpati, Kendrapada, Keonjhar, Koraput, and Raigada, wherein
The next supervisor.
the case detection through active case detection method was directed to be immediately stopped. The court expects that on the next date, the state shall justify such communication, such instruction issued by the Directorate of Health to the Chief Medical Officer, Chief and District Medical Officers, Chief District Medical Officers. Yes. Anything else?
Item number 23.
Please, Your Lordship. In item number 23, there is a noting that the accredited for 2024 may kindly be seen with the defect number 11 that is need legible copy of page number 41, 55, 57 and 58 not expired. Today I am filing this.
Filing what?
Defect number 19 as per is not removed. That all. I will wait for the.
Defect 19.
That also.
Page 41, 55, 57, 58.
All right.
That you have filed? Already. And defect 19 is also some illegible copy.
Yes.
That you have filed or will file?
That file.
All the defects you have removed.
Removed.
But why are you showing the defects?
Today I am filing.
Today you will-
I pray for his adjournment because the conducting counsel, Mr. Pranay Mohanty, is suffering from throat infection. So.
What is this matter?
Matter getting to
Been continuing since 2011, Your Lordship.
Yes. When do you want?
What is your name, please?
Sanjeev Kumar Sahu.
Yes, sir.
Seeks adjournment to remove the defects as pointed out by the registry. Proper as requested, does this matter on 3 weeks? Yes.
Item 24.
Please, Your Lordship. Your Lordship, I'm challenging the bid of the application of the tribal opposite party number 6 in respect of the auction of the sand for Your Lordship. Your Lordship, the brief fact of the case is that the tender application was called from the participants as individual capacity, Your Lordship. However, this opposite party number 6, being the second highest bidder, has applied for the application and has submitted the income tax return as Hindu undivided family, Your Lordship. And my arguments are two-folded, Your Lordship. First is that there is no specific provision, Your Lordship, which says that any juristic person or Hindu undivided family can also participate when the tender notice specifically calls for participants in individual capacity, Your Lordship. And secondly, the very intention of providing the income tax return is so that in case of default or in case that the statutory government dues are not paid, then the recovery can be made from the applicants. And in this case, when the income tax return has been filed of the Hindu undivided family, the same cannot be recovered from the Hindu undivided family ownership. However, even if there are no provisions, arbitrarily the selection has been made of this opposite party number 6 year. Therefore, I'm challenging and since the petitioner is the next highest bidder, Your Lordship, hence prayer has been made to settle the query in favor of the petitioner.
On the last occasion, there was a direction to serve the copy of the writ petition.
Have you entered appearance on behalf
The
of
copy
the
I have not received the copy, ma'am.
No, if you don't appear, why should they serve copy on you?
It's on the last occasion. I don't know what I am married.
You filed Wakalatnama on behalf of opposite party number
Yes,
6.
I undertook, Malach. I have the Wakalat now and I don't know what opposite party I am, ma'am. On the last occasion, I requested for a copy.
Lordship, notice was issued, Lordship, copy must have been served. I have
So
served.
that's all right, but till date he has not filed Wakalatama.
Well, I'll
What
file in the
strength is
course of the day,
appearing, I
ma'am.
don't know.
I'll file it today, ma'am.
File it. You can be entitled to a copy of the notice only, a copy of that writ petition only after you
I'll file it today.
file your account.
The Lordship may have two writ applications. You
I'm
can
serving a copy.
In second, I have appeared, ma'am.
All right.
Copy of the writ application. Copies of the writ application. There are two.
One is fine.
First, you file your
File
account.
it.
Mr. So and so states that he has instructions to appear on behalf of opposite party number 6. Opposite party number 6. And he shall be filing Wakalatnama in course of the day.
File it.
In course of the day. Stop. List this matter on 2 weeks. 2 weeks. In the meanwhile, let copies of the copy of the writ petition be served on the blood council for the on Mr. Swayam.
Item 25.
Lordship can take it up on Monday.
Monday not.
It's a very short topic, Your Lordship, it may be decided.
It's very typical. He may file counter affidavit. Don't know. Yes.
25.
Hello. I'm appealing for the respondent. But I have some preliminary objection regarding maintenance. So that's a very short point. If your Lordship will kindly look through the item number 2, sub item number 2. Read appeal number 19 of 2024.
Yes.
Lord, what had happened, writ petitions were filed, those were disposed of on merit. Thereafter, application for review was filed. And no sooner the review application was rejected, then writ appeals have been preferred before this bench. What has happened, if your Lordship will kindly see, writ appeal number 19 of 2024, this is an appeal against an order rejecting the review petition.
And the writ petition?
Has not
Order
been
passed in the writ
No,
petition?
that has not been challenged. And order 47 rule 7 clearly envisages that no appeal shall lie against the order rejecting a review petition. Had it been allowed, then appeal will be there.
But he can make a submission that the provisions of CPC do not apply.
My lord, in that case, my lord, that was also the contention in several cases before the apex court, where it has been said that Article 136 also, for that also, the apex court said that order 47 rule 7 will apply.
No, the principles may apply, but the law does not apply.
Exactly, my lord, but they have taken into, my lord, the apex court has said that order 47 rule 7 will apply. Taking specific note of that provision.
So this is about WA 19. What about other writ appeals?
And other appeals, what has happened? If the main judgment is challenged, as well as the review order, then one has to file two appeals. A single appeal was filed, where the judgment passed in the main petition as well as in the order rejecting the review. Both were challenged. And interestingly,
No, that is true. See, there are two orders. One passed in the main writ petition and the other in the review application. The order passed in the writ petition may be challenged without challenging the order passed in review application. It can be challenged on the ground that, and they can seek condonation of delay also on that ground, that he was pursuing his remedy by filing review application.
Exactly. That's a settled position of law. There is nothing to quarrel about it. But one appeal was filed. Judgment passed in the writ petition was challenged, and judgment order passed rejecting the review application was challenged. But while doing the stamp report, the period of limitation was computed that as if the appeal is presented against that judgment passed on review of petition. So therefore, 251 days delay, I have calculated almost 251 days delay in each of the appeals are there. No application for condonation of delay also. Single appeal, no application for condonation of delay, all these happened. Lord, that's why my submission would be that apart from 19 of 2024, rest of the matters, Lord, probably there may be a requirement of a further stamp report. Because office has to examine that aspect first.
Yes, Mr. He appears to be correct. If you challenge an order, which is, if your appeal is barred by limitation, then you will have to apply for condonation of delay. And you may take this point that you were pursuing your remedy by filing review application. That can be a ground for condonation of delay. But unless you do that,
Regular matters.
Because after disposal of that review petition, this was filed, and it was within the time limit of 30 days. No, I am conscious of that. The stamp reporter didn't objected to that, and it was also hard. And notices have been issued. Maybe this is a hyper technicality.
No, not hyper technical. You prefer.
There will be something will be. The stamp reporter will.
This is not at all hyper technical.
File a petition to that effect. There is no dispute. I cannot have it. But the issue on the merit is, my lord, the repetition was disposed of in the premises. The court has adjourned. Just the merit of the case. I'm just trying one line. The repetition was taken up at the instance of the honorable single judge on the ground in a particular date. The order sheet I have also shown that the maintainability of the case against the institution was to be taken into consideration. But what the court has done, court has gone to the merit of the case also and dismissed the case. Both. That is why this was accepted by my lord. Only this on small issue. Because the review also said the review was filed on only particular that ground. And that was also dismissed. No, I have decided on merit. That was the ground. That is why it was clubbed together. My lord will that the further staff reporter by the registry takes steps.
A preliminary objection has been raised on behalf of the respondents in WA number 102 of 2023, 24, comma WA 67 of 2024, WA 68 of 2024, if all of it, up to 101. That the
Accepting 19 of
same are
which is not measurable.
Accepting
WA 19 of 2024, which is
same
not
are
measurable.
barred by limitation. And the stamp reporter has not correctly pointed out the delay. So stop. It has also been submitted that there is no application filed on behalf of the appellants seeking condonation of delay. Though there is a delay in preferring the appeal. Stop. As regards WA number 19 of 2024 is submitted on behalf of the which respondent?
Respondents 3 and 4.
3 and 4. In all the cases, 3 and 4.
In 19. In that
3 and
case,
4.
3 and 4. Other cases differently numbered.
Contesting.
Contesting.
That would
submitted.
Contesting respondent.
That the said writ appeal has been preferred against an order passed on a review application seeking review of an order passed in WPC 3150 of 2020. However, the order passed in WPC 3150 of 2020 has not been assailed in the present inter-court appeal, and therefore the inter-court appeal against an order passed in review application is not maintainable. So stop. Next, we are satisfied with the submission advanced on behalf of the respondents that the stamp reporting has not been correctly done to the extent the same relates to the determination of delay in filing of the writ appeals. So stop. Let press stamp reporting be done. Stop this matter. Yes. 2 weeks.
Item number 26.
Milord, in item 26, I'm Naveen Kumar appearing through VC, Milord. Yesterday, it was adjourned because there was no person appearing on behalf of the OP number 4, Milord. Today, my learned friend is here, Milord. And OP number 5 have filed Wakalat Nama, but they have not appeared, Milord. They have filed Wakalat Nama, that was, I was told, Milord.
5 has filed Wakalat Nama? Where?
Amrita.
Lordship, I'm appearing for the petitioner, but on the previous occasion, I have tried several times to check whether OP number 5 has appeared or not, but according to this
OP5.
Five. Nobody has appeared for OP5. Doesn't matter. Notice has been sufficient.
Lord, the state has filed their counter, Lord. Others have not filed counter. The state has filed counter, Lord. And in counter, they have accepted the fact that there was a report from the Tahsildar. So the very basis for rejecting my application is now factually incorrect, Lord. And my first ground in the petition, Lord, and the review petition is that the applicant, my father, died on 9 January 2005, and I intimated on 31st March 2005 And despite that, the communications was sent in favor of a dead person, and the order was also passed against a dead person. And that is my first ground, my lord, that the order of rejection of my application was a nullity. It is completely null and void, and that is what Supreme Court says in Gurnaam Singh, that when person dies, then the authority becomes without jurisdiction, and order passed against a dead person becomes a order in nullity. It can be challenged even in execution stage. It can be challenged in collateral proceedings. Also, it has no effect.
That is not general principle, Mr. Naveen Kumar. It will depend. See, if someone files an application and before any decision is taken on that application, the person dies.
Yes, my lord.
Or dies, and after he dies, an order is passed rejecting the application.
Yes.
So that order cannot be said to be nullity on that ground.
Yes.
That is different. In your case, you may be correct. This principle may apply, but
You will also kindly see the order.
Let me place my case, my lord. The para 6 of, may I show that judgment?
no, we remember, Mr. Naveen Kumar, there was some merit in your submission.
Yes, that's why my lord,
the notices were issued.
Yes, yes, my lord. So that's why my lord has issued notice. My lord, let me refresh, my lord. Let me show the order passed by this court rejecting my application, my writ petition on 18 June 2024, because that quotes the order of the estate, my lord. And then I'll show the issue wise.
Just a minute.
Page 19 of my
right to inherit.
My lord, may I show the order? Page 19.
Yes, that was the reason why we had issue notice. In any case, the petitioner who is a legal heir of so-and-so does not have any right to pursue this matter, as the said communication relates to rejection of an application for grant of QL.
Yes.
And that is...
Yes, my lord. And why my lord has issued notice? Because on that day, I saw the rule 58 of the 2004 rules. Rule 58 says, may I refer to that rule? Amrita has that book.
Yes.
That rule gives me a right, my lord. Let me show that rule and then I'll...
And what about delay, Mr. Naveen Kumar?
My lord, let me show issue, my lord. There is no ground for delay. Let me show the issue 58, rule 58, that Amrita will give that book, my lord, not in MMDR, my lord. This is minor mineral rules. This is called Orissa Minor Mineral Concession Rules 2004. Though there is a similar provision in Rule 25A of Mineral Concession Rules, but I am referring to this particular rule because I am governed by this rule, my lord. I think it page 128 of the book which Amrita has handed over. If my lord is holding same book.
Which rule you are referring to?
Rule 58, my lord.
Just a minute.
58.
Yes.
A status of grant on death of applicant or prospecting license or mining lease or quarry lease. My lord, may read Roman 1, where an application for grant or renewal of prospecting license, mining lease or quarry lease dies before order granting him license or lease or its renewal is passed, the application for grant or renewal of license or lease shall be deemed to have been made by his legal heirs. So there is a deeming fiction that I inherit the application on behalf of my father on his death. And my lord, it is undisputed fact that I have immediately intimated about the death, about the legal heir certificate, and no objection certificate from other legal heirs. So I get right to pursue that application, my lord.
Yes, Mr. Who is for the other side?
I am appealing, my lord.
Yes, in that view of the matter, the order can be recalled and the.
Yes.
Before that only, I will take 2 minutes maximum. The order passed in the writ petition, which has been sought to be reviewed. That is available at page 20, para 3.
Para 3, we have referred to the delay, but
No,
paragraph 4 is clear.
No, I am not on that, madam.
Okay.
Delay. I am not speaking about delay. Para 3, may I read, madam? Learned counsel appearing on behalf of the petitioner has submitted that when the communication dated 4/1/2008 was made, the applicant T. Bengal Rao was no more, who had died on 31/1/2005 itself. He has submitted that the impugned communication dated 4/1/2008 is therefore against the dead person and thus not sustainable. The petitioner is legal heir of the applicant in response to which application the communication dated 4/1/2008 was made. Learned counsel for the petitioner has argued that there are valid reasons for not approaching this court soon after the communication dated 4/1/2008 was made. Thereafter, your lordship's order. We see no illegality in the impugned communication dated 4/1/2008 as noted above. In any case, the petitioner who is legal heir of P. N. Bengal now doesn't have any right to pursue this matter as the said communication relates to rejection of an application for grant of query.
So this is.
My submission is my lord. Your lordship took note of these things about the death of his father, her father, and your lordship came to a conclusion that this is not a good case. There is no illegality in the order passed. If he is agreed by this order, certain other forum is available. Review, my lord. Review.
Yes, I very clearly remember this case because the state council there had asked him that there is a provision somewhere in the act or rules which permits the legal years to continue. He did not point out, so I specifically remember this case.
I was not there
No,
that time.
And in any case, we pass the order in ignorance of Rule 58.
If your lordship wants to that, thereafter I cannot have any solution. In that event, I cannot have any solution.
State council did not assist. So specifically I had asked.
I was ready going through Order 47, Rule 1. So,
That one, it was there in the back of my mind that provision is there. Because number of applications, the legal years step into the shoes for these applications.
yes, possibly I couldn't express myself properly. Possibly.
Paragraph 3 is there, but paragraph 4 is clear.
Paragraph 4, your lordship have come to a conclusion there is no illegality. If he is agreed, he should have approached the Honorable Supreme Court.
All right.
My lord, may I submit two? My lord, two statements.
A second, now we will pass the order. Yes, Mr.
My lord, may I make only two submissions to the extent of the paragraph 4, the right to pursue, my lord, Mr. Naveen Kumar is a right as far as the Rule 58, but that Rule 58 is no more there with the effect from 2016. That's point number one. And even otherwise, my lord, this cause of action is actually infructuous. To the extent of the review, perhaps your lordship should be inclined to recall that portion of the paragraph 4.
Only on that ground, thereafter merit we can check. So
Yes, my lords. Yes, to that extent, I just thought of informing your lordships.
Not now. Mention tomorrow.
My lord, that's not older lady. I mentioned this matter before vacation, and your lordship directed to list this matter. Unfortunately, this matter was not listed. So, I mean, lady of 70 years.
You should have mentioned at 10:30 in the morning.
Of course, I understand.
All right, mention
Your
tomorrow.
lordship may see my condition.
Make a mention tomorrow. Yes.
From 26th.
May I please, Your Lordship?
Yes. We are recalling that order.
Lord, before your lordships, may I give one small proposition for my lord's consideration, a small, only one-liner, that if the final relief of the writ petition is injuncted by operation of the law because of the amendment in 2016, would your lordships recalling of this, the order review will suffice and cause any substantial justice to the parties? Because even if there is an error, apparent error, your lordships have discretion under section 114 to pass any order in the interest of justice. Because at the end of the day, there is no relief post 2016 December amendment to the law. And that has been challenged, that has been, my lord, upheld as of now. So even if your lordship should revive the writ petition and the relief is as such on that same alone, one ground alone.
That will be seen.
All right.
That will be seen later. The present review application has been filed in review of an order dated 18/6/2024, passed in WPC number 11889 of 2024, whereby the writ application filed by the petitioner was dismissed with the following observation, paragraph 3 and 4. Stop. Observations. Next, learned counsel appearing on behalf of the petitioner has submitted that the observation made by this court that the petitioner did not have any right to pursue the matter relating to pursue application for grant of quarry license. Consequent upon the death of the original applicant is contrary to the provision under Rule 58 of Odisha Minor Minerals Concession Rules, 2004. First off, he has submitted that the order of said order of this court dated 18/6/2024 was passed in ignorance of the said provision under Rule 58 of the rules. Stop. Rule 58 of the rules reads thus. Stop. We are satisfied with the submission advanced on behalf of the petitioner that we fail to notice the provision under Rule 58 of the rules of 2004, which states that where an applicant for grant or renewal of prospecting license / mining lease or quarry lease died before the order granting him license, lease, the application for grant of license can be deemed to have been made by his legal heir / representative. Stop. Next, Mr. Das and counsel appearing on behalf of respondent number 5.
The opposite party 4, Lords. Opposite party 4
has submitted that OMMC rules 2004 have been repealed by OMMC 2016, which does not contain similar provision to that of Rule 58 of 2004 rules.
My correction, Lord. Correction, Lord. No, there are similar provisions there. I'm not saying that. That is a similar provision is Rule 40. So there is a provision. I'm not saying that, my Lord. I'm only saying 412. 412.
He is going on merit, my lord, without filing counter.
412.
And
It's a pure question.
All right. Accordingly, the order dated 18/6, accordingly, in our opinion, a case of a review/recall of the order dated 18/6/2024 is made out. The said order is accordingly recalled. Stop. Next, let WPC number 11889 of 2024 be restored to its original file. Counter affidavit has been filed.
no, my lord, review, they have filed counter to review, not to the writ petition, my lord.
All
They
right.
have not filed counter to review, writ petition, my lord.
Right.
So let them file counter to writ petition, my lord, now.
Let the petition be taken up first.
Yes,
Yes, next.
Item 27.
deeply.
Heard, son.
Question are similar. This case, there are questions that controversy.
WPC number so and so will listed for the submission. Before appropriate bench on 4 weeks. Yes.
And for the petitioner, the public grievance, the Tapangogoda villages of in the Khoda district.
What happened?
That is it is a public grievance by the Tapangogoda village of Khoda district near Hatia Hill. They, due to the granite mafia miner, the village roads as well as the schools and hospitals are damaged.
Counter affidavit has been filed.
No, my 3 weeks time may be granted for selling.
For the OP5, my lords, I have filed counter, my lords.
Is the opinion that is, I have not grievance against that, my lord. But the collector for the OP2 to file the counter. Because the Tahsildar already reported before the collector that the pollution is going up.
All right, file for counter affidavit.
I'm acting for the opposite party number 6.
Despite order of this court
Last occasion also he is taking time.
dated 25/6/2024. No counter affidavit has been filed on behalf of the opposite parties number 1 to 4. List this case on 6 weeks so as to enable the state respondents, opposite parties, to file counter affidavit. Stop. Positively. Yes.
Item 28.
58 million, the first item, and for the petitioner, my case is regarding DO Education Department of Baleswar with some fake certificates. Some persons are appointed and taking the salary, monthly salary from the government. I oppose that. Then the crime of Baleswar district reported to the DO Baleswar to submit the report about the fake certificate. Till then, the DO has not filed any report before the Lordship time to page 29. Page 29. This is a crime branch Katak Miller. Last paragraph. It is requested to the district education officer. It is requested
Yes, have you
to
filed counter
inquiry.
affidavit?
Your Lordship, in the connected 1875218 and 16724 are directed the director of elementary education to file a comprehensive affidavit. And earlier in July, he had filed an affidavit. This is about the updated information. She has sent some information 2 weeks may be given, I will file the affidavit, giving all details.
But my Nana senior said the elementary education, but it is the secondary education, the high schools.
About that aspect also, I will file the affidavit. Because today, for the first time it has come, a lot of notices are there. So far, I am concerned.
Today is the third time.
Next time some other council may be there.
Oh, all right, I will. Let it come 2 weeks after, I will
752.
file complaint affidavit and all details that is required.
Have been appointed by your lordship as the amicus. These aspects are already being dealt with. And on the last occasion, if you have the transition in the Attorney General's office, new council is taking over. So the state council had asked for some time to file a counter affidavit. As per your lordship's direction dated 16/7. So I think on that ground, he's seeking time. And as you got the first case, these are already being dealt up with in that case.
In my case also, I also turn to page 14, WPC 17579. This is a letter of the Superintendent of Police to Director of Secondary Education. Page 14, first case, page 14. Last paragraph. After verification, the matter has been referred to Director of Secondary Education. Which
Yes, let them file affidavit.
Rough is there. The rough.
Take,
In that 1.395 of 2015, you could see 27/6/2024, Lordship passed an order directing specifically to the state to upload information about all primary elementary schools in the website. But pursuant to that, they have filed an affidavit stating therein that 47,310 schools, out of which they have given an affidavit and the statistics in respect of 24,633 schools. But this affidavit they had filed on 12th of August 24. For the balance schools, they have not yet given affidavit nor the informations are uploaded. But I have also tried to go through this whole 4,000, 3,000 pages of affidavit. Here, I have found that serious lacunas and serious discrepancies are there with regard to maintaining number of teachers with respect corresponding to student strength, classroom situation, playground situation. But there are discrepancies. So I request my lords.
The second writ application is regarding facilities available.
Basic amenities and
First one is that without there being teachers, fake certificates.
it is secondary high schools.
Like the last case includes all those aspects with regard to midday meal, fake certificates, appointment of engagement of enrollment of students in various schools, primary, secondary, and all those things, without keeping record. All those cases are covered in the aspects are covered in the third case, second sub item.
I beg to submit me that I filed an intervention petition, my
I
lord.
think that has been rejected earlier.
My lord,
Your intervention has earlier been rejected, I think, if I remember correctly.
my lord, I the judgment of the Supreme Court.
Judgment of the Supreme Court.
Whereas the primary school.
No, judgment of the Supreme Court stating that the intervention should be allowed. No.
To apprise the court, my lord, that the fake certain primary school teachers, their ED is not required. That is the judgment I don't know.
What is required?
Correct.
It is not required.
Primary school teacher up to class 50 minor. BEd is not required. BEd certificate, that is my lord. By my lordship, she.
So without requirement, you filed the B.Ed certificate.
Oh my. That is not.
There was no requirement, but you filed.
My lord,
Fake.
my lordship appreciation, I filed the judgment of the Supreme Court that primary school teachers know.
But who are you?
I filed the intervention petition.
But who are you? Who are you?
All of the teachers.
Fake.
10-20 ବର୍ଷ ହେଲା ଚାକିରି କରିଛନ୍ତି ପ୍ରାଇମେରୀ ପଞ୍ଚମ ଶ୍ରେଣୀରେ।
May I submit, my lord, my case is separated, listed separately, my lord, because it is a secondary schools. They are the elementary schools. So director of secondary education to be filed the counter. First case.
Let it come after 2 weeks after whatever written requisition on behalf of the government will file the meantime manner, either secondary or elementary.
No, that we listed separately.
Only that first item? Yes, sir.
What about this order dated 16/7/2024, passed in WPC 18752 of 2018?
Yes. That is seeking time for that.
file an appropriate affidavit disclosing a clear picture on the point of misappropriation of amount of midday meal in the wake of allegation that the said amount has been spent in the name of children who do not exist.
Directly elementary education file for which I am seeking for 2 weeks time, my lord. Certain information they have sent to us. My lord?
Gone through the brief.
Yes, yes.
In fact, if your lordship has a letter which in fact includes all those allegations which are now raised by my learned friend.
What happened?
This letter which was referred to your lordships.
Letter?
Last second sub item. 18752. Basing upon which your lordship had issued notice. In fact, if your lordship see the letter, the fake student aspect, the fake teacher aspect, both at the elementary and secondary education stage, those aspects have already been looked into in that litigation itself.
But the last one includes that.
Yes.
Fixing second order was there a direction to elementary, direct elementary education to file the affidavit. That's class.
The lordship has a letter. I think that is email has been taken out by this honorable court's
9/5/2023. You are referring to this letter.
Lordship, it's a printed letter of this honorable court from the email sent to it. And it's dated 11/8/2018. It's reflected at the top.
Where is that?
This by lordship, immediate reference. This is the letter. I think prior to my being appointed as a mitre, this letter was received by the honorable court. At the top, your lordship sees the High Court email ID is there at the top. I think on the basis of this letter, the entire PL was initiated. In fact, that is dealing with that letter. We believe that it deals with all those aspects which are now being raised in this press rate application by my learned friend.
So the first rate application relates to WPC 17579.
7 Miller, you'll also turn to page 19 Miller.
Mr. You are appearing in this case 17579.
17579.
All right. This relates to what?
Fake certificate with the fake certificates, some teachers are appointed and taking monthly salary from the government. And the DO, my lord, your lordship, turn to page 19.
Just a minute. This is secondary education or elementary education?
Secondary education.
Secondary education. So this has come for the first time.
Notice issued and this second time it come.
Second time.
Your lordship, turn to page 19.
Just a minute. Let me. File your affidavit in the first case. Some alag letter. 17579 of 2024. The present writ petition in the nature of public interest litigation. The petitioner has alleged that certain persons have been appointed as secondary education teachers. What do you call? Secondary education teachers based on fake certificates, and they are illegally drawing fake certificates. The court had directed the state opposite parties to file counter affidavit by an order dated 12/8/2024. Till date, no counter affidavit has been filed. by way of last indulgence, 3 weeks further time is allowed for filing the counter affidavit, failing which the full stop. If no counter affidavit is filed in the meanwhile, list this matter on so and so. If no counter affidavit is filed in the meanwhile, the court shall consider imposing cost on the concerned opposite parties.
And the jury which is separate.
Let WPC number 18752 of 2018 be 18 and WPC 15395 of 2008-15 be D-tagged from the present matter. Yes. Let us come to the next case now.
WPC 15395 of 15.
That's right. But may kindly come to flag 103. Flag 103. Actually, we come across the order quoted hearing 27/6/2024 and the affidavit filed by the state. Flag 103.
Yes.
Lordship will see the specific order passed by my lords 27/6/2024. Lord, your lordship has been quoted hearing. We have noticed apparent clerical errors in the format.
No, that was the order. That was the case where we had directed for uploading of certain information. Whether that exercise is complete or not.
But that exercise is not yet complete. That's their own affidavit. Page 3, your lordship may see the bottom paragraph. As of now, data on the availability of basic amenities in respect of 24,633 numbers of schools having elementary sections in composite schools have been entered.
You are reading which paragraph?
But I am reading page 3 of this affidavit, flag 103.
102.
Flag 103.
3.
Right.
Which paragraph?
But this is para 5, bottom portion.
The block, it is so to mention here.
As of now, the last bottom.
As of now.
As of now, maybe permitted to place it.
Yes.
As of now, data on the availability of basic amenity in respect of 24,633 number of elementary schools and schools having elementary sections in composite schools have been entered out of total 47,310 schools. The detailed information of 24,633 schools in the prescribed format has been uploaded in the website of the state government and now is available in the public domain in compliance with the order passed by the Honorable Court. Then your lordship may see para 6.
Yes. Yeah.
This data is dynamic in nature and subject to verification due to time constraints and large number of schools. Data reported has been complied. Random verification of the data received from the districts will be taken up subsequently by the officers of the department. So almost 50% they have supplied by this affidavit. I tried to search this data in the website, but I could not find it. Maybe ignorant about that website. That must be somewhere else. But I could not find it. Secondly, I have verified this whole data. If lordship sees not huge numbers, I could find that there are discrepancies with regard to teacher required number of teachers are not there in the schools corresponding the number of students. That is there. I have found out.
That is, but incorrect information has been given in the affidavit.
Yes, Miller. In the affidavit itself, whatever numbers are disclosed, that doesn't meet the requirement.
No.
The information is correct.
Yes.
But the information suggests
Right.
that the teacher-student ratio
Is not maintained.
Not maintained.
But that's a very prime requirement. Suppose there are 60 students reading in a school and you are providing
We
one.
were worried that they have given wrong information. Then correct.
I cannot make it.
Yes, it is very difficult for him to say whether the
Yes,
information
very
is correct or not.
Unless I visit those schools again, I cannot say. And secondly, Lord, I have been coming across several reports.
So, but Mr. Rath, you will have to tell us
Right.
exactly as to.
That exercise I am taking.
So please ask your juniors to do.
Yes, I have asked. But since it's very voluminous, they are working on this.
Senior counsel, Mr. P.K. Rath, Senior counsel. appearing as Ms. Carey has submitted that he shall be preparing a list to assess this court based on the disclosures made in the additional affidavit filed by the Commissioner cum Secretary to the Government of my School and Mass Education Department, bracketed flag 103. So he has submitted that prima facie it appears based on the said information that teacher-student ratio in many of these schools, requisite teacher-student ratio in many of these schools has not been maintained. So stop. List this clear. How much time? 2 weeks. Same day. It will be. Same.
29th January.
Same. 29th January.
3 weeks, no? 3 weeks.
3 weeks.
Last one. Syllabus, again,
18753. So. Make all the next one.
No, so last one will also come along, so along with that one. 3 weeks along with the last one.
Item 29.
I thought I am for the petitioner. This case pertains to illegal construction of buildings around a national monument of national importance near Chunagad, locally known as Sarangad, at Dadhapatna district, Kottakkal, Khurda. So we have submitted sufficient copies to the opposite parties, but till now we have not received a copy of their counter. And I have filed one IA.
Yes, why have you not filed your affidavits?
2 weeks time to file. And the state has to give it, but in fact.
State is busy.
In fact, the encroachment also made by the state. You will also may kindly see at page 96.
Who's appearing for the state in this matter?
Because we have written to the chief secretary by the superintendent of Center that the encroachment also made by the Department of
The Archaeological Survey of India has not given any permission. And IA number 10371 I have filed and I have requested for stoppage of illegal construction in around this area.
I will take instruction.
You ask to take instructions, this is a serious matter. Monument of national importance, he has complained about encroachment and illegal occupation. You were asked to get instructions. File affidavit, 2 months have elapsed.
It will come next week, my lord, I will take instruction.
Meantime, what I kindly pass stopping illegal construction.
Illegal construction is permitted as on date.
It's going on there.
State will stop.
Yes. So we will take up the matter tomorrow.
I will take instruction.
Tomorrow, and you will have to inform this court whether from tomorrow there any authorized construction
But we stop.
can be allowed or not.
Yes.
All right. Tomorrow.
Item 30.
Tomorrow. The petitioner in the presented application has alleged unauthorized encroachments having been caused around Chunagad Fort What is the name? Churangagarh Fort in the district of Puri, which is monument of historical importance.
Yes, madam. Yes.
Learned counsel in the district of Cuttack. Learned counsel for the petitioner has submitted that persons are still making illegal encroachments, construction around the said fort. First off, despite opportunity granted to the national importance, national importance की जगह पे लिखो थोड़ा, is a centrally protected site.
Yes, madam. Your lordship may kindly look at the page 96.
Centrally
That we are
protected site
written to
and
the,
has been declared as a
Chief
monument
Secretary
of
to take action.
national importance. White Gazette notification dated 4/1/2000, 4/1/1954. So, despite opportunity granted to the opposite parties, no counter affidavit has been filed. So stop. List the matter tomorrow.
May I pray, my lord? Can it be Monday, my lord? Because all the officers are, because the Pravasi program.
As to how much time will the opposite parties may take for filing the counter affidavit? How much further time? So stop. He shall also seek instructions as to whether the opposite parties are willing to stop further illegal construction, if any, around the said fort. Yes, tomorrow.
Item number 30.
May I please, my lord? Here the grievance is work worth of about 50 lakhs. In fact, 60 lakhs has been sanctioned by the government in favor of different schools for developmental work. Now that is being executed departmentally instead of putting it to tender, thereby adopting opaque method without having any transparency. Now, my lord, your lordship will see Annexure 1, page 10. Initially, Annexure 1, page 10, your lordship.
So whether counter affidavit
yes, counter affidavit they have filed, and in the counter they say on the basis of verbal instruction of the authority we have done it. That is at page 2, paragraph 5. Now, can it be, my lord, when they have circulars in place that any work worth more than 10 lakhs has to be done through tender process? They are saying we have done it verbally on verbal instruction, and out of 50 lakhs they have executed work worth of 8,53,027. That's what they have stated in paragraph 5, your lordship. So this is apparent admission on their part that they have not done it in accordance with the procedure prescribed by them. And this is being done throughout the state, my lord, having no accountability. Though the writ petition is concerning only one school, that is Narayan Vidyapitha.
But what is wrong in it? What is illegal about it?
But illegal is, my lord, they themselves, your lordship will see their own circular at page 19, paragraph 1. They say this circular is correct, resolution. In the counter, they have admitted that they are doing according to this in accordance with this resolution, I'll show to your lordship from the counter. Your lordship may kindly see page 19, paragraph 1. The existing system of selection of village level leader for execution of the developmental work up to 5 lakhs is done away with immediate effect, and all the works in which the project cost is up to 10 lakhs shall be taken up departmentally. The work costing more than 10 lakhs shall be taken up through transparent and competitive tender process following due procedures as laid down in OPWD code and Orissa Panchayat Samiti accounting procedure rules and OGFR. Now your lordship will see their counter affidavit. They have admitted that they are doing.
Other provision he is keeping.
Yes, okay.
I'm not skipping anything. Your lordship will kindly see.
Next page 11, next page 11, your lordship may kindly see. Page 20.
I'll place it. Before that, your lordship may kindly see paragraph page 3 of the counter affidavit, paragraph 9.
Yes.
Your lordship will see they have said towards the middle portion in terms of resolution that is 13/7/2018, that is annex 3, your lordship. And that's maybe erroneously typed as 13/7. The procedure prescribed under Rule 14(1)I of the OGP Rules 2014 steps have been taken. Then they have quoted the rule. Now, my lord, once it is more than 10 lakhs, it has to be through tender process, my lord. And this is not, this is having wide ramification in the sense it is throughout the state of Orissa. And work out of, because 10 lakhs is being written by the school headmaster as per their decision, and the rest 50 is being spent departmentally without having a auction tender process. And this is for the entire state. Your lordship will kindly consider the ramification of it. And no, my lord, accounting anything.
Who are
And
you?
they have,
Intending tender, or who are you?
I am the, your lordship, have indicated that. But the petition number 1 happens to be member of the Konak Gram Panchayat, PS member, and petition number 2 is the Naib Sarpanch. They are also involved. So they have come up before your lordship, my lord.
Yes.
Our grievance is with regard to Madanpur school, which is
Mr. Just, yes.
My land friend was placing annexure 3 at page 19. Your lordship may kindly see, after placing serial number 1, clause 1, thereafter he has not submitted anything. Next page, your lordship may kindly come to 11, clause 11. For smooth and expeditious execution of the developmental work of the GP, the procedure contained in Rule 14(1) Roman I of OGP Rule 2014 shall be followed, and for measurement of the check measurement of the work, the procedure is outlined at para 9 shall be strictly adhered to. Measurement, check measurement, it is available in clause 9. There is no difficulty over there. Now your lordship may kindly see Rule 14(1) Roman I of OGP Rules 2014. That allows us
14.
Rule 14(1) Roman I.
Where is that?
I have quoted that also. In my counter, I have quoted that. Your lordship will find that at page 3, internal page 3 of the counter. It is in para 9. It has been quoted. Works under clause Roman I of subrule 1, subrule 2, and subrule 3 of Rule 13 shall be executed in the following manner by the Gram Panchayat departmentally without engaging contractor. This is the provision prescribed with 14(1) Roman I. Without engaging contractor, we can conduct it departmentally. That is the legal provision.
And this work has been undertaken by whom?
Departmentally, by BDO. Man.
Oh, but this requires by Gram Panchayat departmentally.
Yes, madam.
So there is difference. BDO.
Yes, block development officer.
Block development officer.
In the Panchayat.
He is secretary of Panchayat.
Yes, he is conducting.
No, my lord, he is not secretary, your lordship.
Yes. He is not associated with Panchayat.
No, he may be, but the permission, everything process may be, but he is not, because if your lordship reads Rule 13 and 14 together of the Orissa Gram Panchayat rule, your lordship will find the works, developmental works that is being allocated to the Gram Panchayat is to be done by the Gram Panchayat. And here they have selected BDO to execute the work. And if your lordship, they have referred to OGFR. If your lordship sees also OGFR, that says any work above 5 lakhs and 10 lakhs has to be done tender process.
So can you do it in a better manner? What is the public interest involved?
Public interest is, my lord, the school that is being, my lord, in our place, the work is being done.
No, whether the
my lord,
standard of work is poor, whether, see, what is the
but there
public
is nothing, my
interest?
lord. No, there is nothing, no transparency, your
But if
lordship.
you
What
are-
they do, now what they will do, there is nothing. And your lordship will see Annexure 1 and 2, nothing is spelled out how that 50 lakhs will be spent. It's only we'll be developing the school. So it makes a complete opaque system, my lord, where nothing is there. What kind of development, what they will do, nothing is spelled out, your lordship.
Have they done anything so
But
far?
they have spent 8 lakhs. They could have very well said what kind of spending they have done so far that
You
8 lakhs
must
is
have seen,
concerned.
you have filed the PIL, you must have seen the kind of construction, the manner in which the 8 lakhs has been
But
spent.
the only thing that this is not the only the case of this school, it's a case of all the schools in the state also.
Maybe, but you have raised the issue.
But here the issue is why we are raising a grievance. Your lordship will see Annexure 1 and 2.
Transparency only, all, everything is opaque.
Annexure 1 and 2 doesn't spell as to what kind of work will be done for spending that 50 lakhs. Your lordship may
All
kindly
right.
see.
All right.
Absolutely nothing.
All right. So
So what is to be-
how much time will it take for you to complete the work? If the work is given to Panchayat, you are Panchayat or Sarpanch?
I am the Naib
Samiti
Sarpanch
member.
and the Panchayat Samiti member.
You are Panchayat Samiti member. So if
And
that
Naib
work is
Sarpanch.
made available to you, how much time will you take to complete the work?
Unless there is a scope of work, saying how much time I will take will not be possible because there is no scope of work. As to what they are doing, that is not there, my lord. That is the whole difficulty.
You want the work to be given to you, no?
No, it is not to me. It can be done by tender process also. It is not that I should, then it doesn't become a public interest. It becomes a personal interest, your lordship.
It is a personal interest.
Annexure 4?
Annexure 4, your lordship.
Yes.
Both the documents are to be read together. Your lordship may kindly see.
Together. Okay.
Not a public
Page
interest.
24, your lordship may kindly see. Page 24, this is in Odia. I may be pardoned.
ମୁଁ ଶ୍ରୀମତୀ କମଳା ରାଉତଙ୍କ ବୟସ ଦେଖିଲେ କମଳା ରାଉତ ଯେତିକି ଗ୍ରାମ ପଞ୍ଚାୟତ ଆଉ ପଞ୍ଚାୟତ ଅନ୍ତର୍ଗତ ନାରାୟଣ ବିଦ୍ୟାପୀଠ ସମଥିଙ୍ଗକୁ ମୁଁ ପ୍ରାୟ କଣ
5ଟି ମାଧ୍ୟମରେ ଅନୁଦାନ ରାଶି ପ୍ରଦାନ କରାଯାଇଥିଲା ଉକ୍ତ ଅନୁଦାନ ରାଶି ଏପର୍ଯ୍ୟନ୍ତ କାର୍ଯ୍ୟକ୍ଷମ ହୋଇପାରି ନାହିଁ ସେଠାକାର ସମିତି ସଭ୍ୟ ଭାବରେ ଉକ୍ତ ରୂପାନ୍ତରଣ କାର୍ଯ୍ୟକ୍ରମ ମୋର ନିଜସ୍ୱ ତତ୍ତ୍ୱାବଧାନରେ ଉକ୍ତ ବିଦ୍ୟାଳୟର ମ୍ୟାନେଜିଂ କମିଟି ମାଧ୍ୟମରେ ସମ୍ପାଦନ କରିବା ପାଇଁ ଆପଣଙ୍କୁ
ତାପର page 24 ଟା my friend is not placing.
He wants the committee.
She na?
She wants that it should be done.
She aged about 72 years. Yes. No, she will do it through her.
Page 24, your lordship may kindly
All
see.
right, page 24.
My lord. लास्ट पैराग्राफ तेणु प्रार्थना करे कि तुरंत डिपार्टमेंट द्वारा कार्य बातिल करी टेंडर द्वारा स्कूल घर निर्माण करा गले समस्त द्वंद्वर समाधान होई परिबो.
Yes.
So it is not that I have said I will do it.
Sorry, Mr. Mishra, we should not encourage such PILs.
This is for my lord tender, I have said.
Purely personal interest litigation.
Now this is what I wanted to beg to your lordship notice, nothing beyond that, my lord.
Sorry. The petitioner is. Where have you described yourself?
My lord, in the cause title itself, your lordship.
Where have you mentioned? Who are you?
I have mentioned in the cause title, not in the pleading, that your lordship.
Not in the pleading, then you have concealed.
No, I have described in the cause title itself, my lord. Working as PS member, Corona Gram Panchayat, District Puri, petition number 1. Then petition number 2, working as Naib Sarpanch, Corona Gram Panchayat. I have mentioned that.
Petitioner number 1 is.
Item paragraph 6 she has stated that she has to supervise the work.
Member, Corona Gram Panchayat. And both of them are members.
Yeah.
And petitioner number 2 is the working Naib Sarpanch of the said Gram Panchayat in the district of Puri. They have filed the present writ petition in the nature of public interest litigation challenging action of the opposite parties in not floating tender in respect of the work sought to be executed for transformation of different schools, including Narayan Vidyapit, Udaipur, Astarang in the district of Puri, which is under Corona Gram Panchayat.
Yes.
Under Corona Gram Panchayat. So, after having perused the averments made in the writ application, and more particularly the representation filed by the petitioner number 1 dated 19/8/2024 in the court's opinion, it is not a public interest litigation, rather the petitioners are interested in their private interest more. To stop this writ application, in our considered opinion, cannot be entertained by way of public interest litigation. This application is accordingly dismissed.
Madam.
कितना है?
Item 31.
Matter relating to deployment of oil. Matter relating to deployment of oil in mining area. The OP number 567 was superintendent file counter, but the Home Department with the essential party has not file counter.
Achha, all these matters will come later. Because I have to take up some other matters. In second. Achha. Yes. Yes.
Wait, please, Raj. This is an application seeking extension of time, the mandate of the honorable arbitrator.
Then you will have to file an application before the district judge.
Lordship, see page 12, Milord, the learned arbitrator was appointed pursuant to your lordship's order. Therefore, I have come before the High Court.
No, therefore the decision, because of the Supreme Court's decision, now we'll have to file an application before the district judge.
I'll do that. Lordship may grant me that liberty.
This application has been filed seeking extension of mandate of the arbitrator, which has expired. Also, after some argument, the counsel appearing on behalf of the petitioner seeks permission to withdraw this application with the liberty to make appropriate application before the arbitration conclusion. वो decision है क्या? Decision. For the court. Before the court within the meaning of section 2 bracketed 1, bracketed E of the Arbitration and Conciliation Act 1996. Extension of mandate of the arbitrator decision.
Lord has been pleased to grant me the liberty to go there.
Yes.
And be clear.
Item number 2.
Please, page 18 is the arbitration agreement. Complete the arbitration clause.
Other compliances?
Next, we notices have come for fresh action.
Item number 3.
This is an application for appointment arbitrator, and the arbitration clause is running page 15, the consultative agreement. And pursuant to the petitioner and the opposite party, they entered the consultative agreement to undertake a project which was floated by NALCO. The work was conducted and the dispute.
The notices were issued by you. You had issued notices
Yes,
for
ma'am.
appointment of her. Issue notice. Yes.
Item number 4.
I'm appealing to VC matters. Matters may short adjournment matters because I filed Vakalkam yesterday and need for LCR also, my lord. Short adjournment.
The trace admission notice is not been issued.
LCR is available, my lords. I will take on pen drive, my lords.
Because this is not criminal division, this is arbitration matter.
Sorry. Oh, sorry. Arbitration. I'm sorry.
There are 2 lists.
ARDP 98 of 2020.
Yes.
The arbitration clause available in page 14.
Yes, issue notice.
Item number 5.
Appointment of arbitrator.
Yes, you accept not to say arbitration clause.
There's arbitration clause at page number,
Running list 36. Time to accept notice. This is matter on 4 weeks. So as to enable and counsel for the opposite party to seek instruction and file objection if required. Yes.
Item number 6.
Taken up a week after. Rather than surgical operation.
As requested on behalf of the petitioner.
Pretty sure.
Unless this matter on 2 weeks. Yes.
Item number 7.
The arbitration agreement is at page 164.
Yes.
14th clause in law of settlement of disputes through arbitration.
Item 7. Yes.
And the compliance is at page 190.
All right.
Item number 8.
Arbitration clause is at page 11. Arbitration clause is at page 11.
Union of India, who is the other side?
Yes, we are appearing, my lord. This case. The first time you listed, we are appearing for this case.
All right. Issue notice, accept notice.
Sir, expect.
4 weeks. 4 weeks, 6 weeks. 6
6 my lord, is better.
Item 9.
Fresh section 11 application. The arbitration clause is at Annex 1, page 24. Notices have been issued, my lords, at page 86, Annex 8.
Issue notice.
For orders, item number 10.
These are the matters where the single arbitrator has been appointed.
That application. I'm dismissing the application.
Item 11.
Same matters. It's my name.
For admission, item 12.
I am condemned under section 11 of the Regularization Act 1996 without wasting valuable time of your worship. I want to invite attention of your lordship, page 43, whereby the settlement of dispute is provided. And page 38, whereby the arbitration agreement is approved. As per the arbitration agreement, and the sole arbitrator may be appointed. I want to invite attention of your lordship.
So who should be appointed?
48, page 48.
Who is appearing for the other side?
Madam, I am appearing for the other side. Objections have been filed. Only one objection. The pre-arbitration procedure as mentioned in clause 45 is not followed, my lords. Page number 48.
Where is the arbitration clause?
Page number 48.
48, my lord. My lordship. Clause 43.1. Towards top.
According to you, it is covered by B,
45(1)(b), my lord.
51B.
Indian Councils of Arbitration that has the procedure states that Indian Council of Arbitration. You can approach Indian Council of Arbitration for appointment.
According to you, the dispute concerns technical, it does not concern a technical matter.
The notice is that regards, it is with respect to the calculation of the amount. That's the notice is that page number 67, annexure 6.
No, there's no question of whether it is the dispute concerns a technical matter. The question is your agreement.
Yes,
If the
ma'am.
parties agree that dispute concerns a technical matter, then it can be taken up by one arbitrator. Otherwise, there is any dispute, it will be taken up by 3 arbitrators. Yes, so is there any dispute over that?
No, regarding dispute, so far as the amount is concerned, I have submitted the claim, and that has been
No.
with respect to
Mr.
execution
Counsel,
of work. So dispute
the
technically.
only question, Mr. Counsel, is whether it is covered by 45(1)(1)A or 45(1)(1)AB.
1A, my lord. I am pressing before your worship. Selection of arbiter, each dispute submitted by a party to arbitration shall be heard by a sole arbitrator or an arbitration panel composed of 3 arbitrators in accordance with the following. So my humble submission would be, my lord, I have intimated with respect the demand for arbitration, appointment of arbitrator. They have never disputed, and according when they failed, I have come up with.
So now they are saying that it does not concern a technical matter.
Yes, in case of technical also, there is the provision for applying to the Indian Council of Arbitration. Clause 45(1)A also refers to Indian Council of Arbitration.
All. Where the parties agree that the dispute concerns a technical matter, they may agree to appoint a sole arbitrator, or failing agreement on the identity of such sole arbitrator within 30 days after receipt of the other party of the proposal of a name for such an appointment by the party who initiated the proceeding, either party may apply Indian Council of Arbitration for a list of not fewer than 5 nominees, and on receipt of such list, the parties shall alternately strike names therefrom, and the last remaining nominee on the list shall be the sole arbitrator.
Sir, Counsel, that is not the question.
No.
The only question is that there is some dispute between you and the other side. If that dispute is admittedly technical in nature or concerns technical matter, if the dispute concerns technical matter admittedly, then it can be heard by sole arbitrator. If there is dispute over that, then it will go before the 3 arbitrators. This is the
I think my mistake, my lords. In the objection, we have said it's a technical matter.
It's a technical matter, then one arbitrator.
In the objection, we have mentioned technical matter.
So there is no dispute over that.
My lords, in that case also, the process involves that it can still apply to the Indian Council of Arbitration.
No, then it is may. Then I can appoint.
Yes, my lord. My lords, I can suggest one.
Both of them?
Manoj Kumar Mishra, senior advocate. Manoj Kumar Mishra, senior advocate.
Manoj Kumar Mishra. Yes.
Item number 13.
Item 13. Notice had gone to the new address. It has been delivered, but nobody has appeared. So let us have a 7 days time that next week.
Does this matter on 2 weeks? Awaiting appearance of the other side, of the other side on whom notices have been served.
Much.
Item 14.
We are filing an objection today itself. So we have a copy on the other side.
Yes, what is your objection?
Yes, we object to the very fact that certain invoices have not been received by us itself.
Certain
invoices, and we have paid the entire bill.
Oh, that matter where you are.
In any view, the matter matters, please come next time. A lot of opportunity given to them.
His objection, my lord, is that he has not got the receipts, my lord, of the.
That is not material for appointment of arbitrator.
My lord, if I may. My lord, there is no dispute. My lord, they are claiming a principal amount. We are saying whatever invoices we have received, we have made payment of that. And there is a dispute over invoices we haven't received.
That is beyond the scope of the present proceeding.
And my lord, if I may. My lord, the invoices we haven't received, there is no cause of action to that effect, my lord. And there's a section 21 notice which they had issued, we had replied. And we have mentioned that these are the invoices we haven't received.
There is arbitration clause, arbitrator has to be appointed, that's all.
Small amount, my lord.
What is the amount?
It's around 40 lakhs, along with interest, as on the date of filing of the petition.
Why not subject to acceptance by them? I would request if it is put to mediation or it can be sorted out.
What
It's not at all a problem because we just want if there is a valid invoice to be received by us, if they can provide us copy, there's no dispute to that at all.
But he may try to prove his case even without the invoices. Don't know.
As my lord.
Suggest a name.
Whether it's Mr. DP Nanda or Mr. S.P. Mishra, learned senior advocates.
Item 15.
My lord, I am for the petitioner, your lordships.
For the respondent, your lordship. On the last occasions, we have taken time to settle the matter, your lordship, but all the amount due has been paid to the complainant.
Yes,
I'm filing an affidavit to that effect.
Yes, my lord. As per instruction, the respondent has already paid the settlement amount.
Then you withdraw it.
Yes, your lords, please, sir.
And counsel appearing on behalf of the petitioner seeks permission to withdraw this application. This application is accordingly dismissed as withdrawn. Withdraw this application in view of developments subsequent to filing of the present application seeking appointment of arbitrator.
Highly obliged.
Item 16.
Melus, I appear for the respondent, Melus.
Yes.
Melus, the objection is filed, Melus. Melus, the sole objection is that, Melus, that the lease deed is not registered, Melus. There should be the compulsory.
You can take before the arbitrator.
Yes, my lord. That will be that only my your lordship, please. Your lordship, please. Anyone, my lord.
But in the arbitration notice, that suggested the name of senior counsel, Mr. Shaktiധർ Das. The arbitration.
Let your lordship decide. My lords may decide.
What is the amount?
Amount, your lordship, is
Around 85 or 86 lakhs, my lords.
86.
The amount is
plus
not
interest.
much, my lords.
Plus interest and damages.
Sanjeev Kumar.
My lords, grateful.
Much obliged.
Item 17.
My lord, on the last occasion, I filed the objection, my lord. But inadvertently, I missed the annexure, my lord. I will file a waive to affidavit.
Lord Counsel appearing on behalf of the opposite party states that inadvertently annexures have not been enclosed with the objection.
Yes, my lord.
Fine. First off, it seeks adjournment. First off, is this matter on 2 weeks? Yes.
Item 18.
But in the meantime, if there is any requirement for rejournment, we'll file also.
That you can.
Item number 18.
Item 18 will pay for another 10 days time. Last occasion I took time to file counter. The concerned officer is transferred, the new officer is joined, they will time within 10 days we will file the counter.
Two times they have taken.
Once after admission, one date you have taken, that is on 11/12/2024 I took time.
By
The
way of
second time
last
paying for time.
indulgence. DSGI, Mr. P.K. Padil and DSGI seeks adjournment to file an objection.
Yes, ma'am.
File objection. Stop this matter on 2 weeks.
Yes, ma'am.
Item 19.
As requested.
From the arbitrator, from last occasion, but considering given a chance to my learned friend, which is on the issue of my learned friend is arguing that it should be sent to RERA because it was a, and my contention it is to be arbitration because these agreements were executed prior to commencement of RERA. And on the last occasion, although I filed 30 cases here, I had filed a charge. I must fairly confess that 6 matters out of this 30 list of matters before your lordship are executed post-RERA. So that, I may have to withdraw it. But the rest, I'm pressing for another 24 matters because these are agreements filed prior to RERA. And I had placed 2 judgments of Honorable Patna High Court, and
so what are those cases? Those 6 cases.
I have already given a I'll just give a copy. Serial number 1 to 6. If your lordship sees the 4th row, agreement to sublease date is all in 2018. So 1 to 6 is 2018, I have mentioned the ARBP number as well. So ARBP 58, 59, 62, 63, 64, and 72 are post.
I'll take up the matter next Wednesday. And you have given the decisions.
I have given 2 judgments, I have got another judgments as well. I've given 2 judgments, One is of the Honorable Patna High Court, and another was of Delhi, where in similar cases, on the conspectus of various judgments, they have held that on the reading of section 80, 79, 80, and 81 and 82 of the RERA Act, it is to be arbitration. I've also got a new judgment of Honorable Guwahati High Court, which is very recent, in July 2024. There, my lord, those judgments have also been considered, along with that, my learned friend was also relying on Vidya Drolia matter of Honorable Supreme Court, where my learned friend was saying that it may not be, these matters may not be arbitrable. That has also been considered in this Guwahati High Court. Maybe if the Lordship wants to take it up next week.
I'll also submit some judgments. The last date also I had submitted.
List these matters on. Six. This the matters. Just on. Next Wednesday.
Item number 20.
Please, Lordship, I'm for the opposite party. I'm with DC, my lord. Maybe pardon. Well, on last occasion, the petitioner took adjournment to file rejoinder.
Who is for the petitioner?
Incidentally, they filed another arbitration petition that is 17 of 24. Withdrawn that. Again, filed this within a very short span of time. Well, this is a petition filed by the son against the father for the purpose of arbitration. So, my lord, we have filed our counter.
No, under which provision? Your father?
I'm father. This is a trust founded by the father, and he is the founding chairman of the trust, People Empowerment Trust. And the son was the managing chairman and the managing.
He is not appearing today.
Well,
Give me some valid reason.
well, so let it be adjourned.
There is no representation on behalf of the petitioner. This matter on next week.
Item 21.
Item number 21, 3 weeks time may be granted for filing objections.
The last 2 times they have took adjournment to file the objection matter. First on 25/9 and second on 23/10/2024. These 2 days they have sought for adjournment for instruction. There is a arbitration clause matter at page 33. They have also sought the notice.
No, where is which? This is our ARBP 84.
Yes, madam.
How do you say 2 times?
And the first matter,
Oh,
the second on 23/10/2024 matter.
huh?
23/10/2024.
Yes. 25/9/2010.
Thereafter on 23/10/2024.
10.
Yes, madam. 23/10.
Order number?
Order number 2, madam.
Thank you. No such orders. Yes. Further time is allowed by way of constant diligence. So as to enable the enable and additions in the council to seek instructions and file objection if so required.
Item 22.
My lord, we are from the opposite party, East Coast Railway, my lord. The last occasion, my lord, issue notice, let's me give 2 weeks time to file counter.
There is no representation on behalf of the petitioner. 2 weeks, yes.
Item 23.
It's 23, I'm appearing on behalf of the university today. I've already filed the count in the registry and served a copy of it.
And this is the copy, only part raised that earlier one ARBP had been filed. Now it has been dismissed for default. But thereafter, subsequently, there was negotiation was going on further communication was made. So must thereafter again we have tried this.
What is wrong in it?
My lords, there are some other issues, my lords. In the ARDP 8 of 2020, the arbitration notice was issued in 2014, my lords. The first arbitration notice. So beyond, in terms of the law laid down the Supreme Court, my lords, Article 137 of the Limitation Act, Section 11 has to be filed within 3 years, man. If not, it's time bar. Secondly, now recently the Supreme Court has also laid down a two-pronged test, which says if the claims themselves are also stale, then it must be considered at the time of Section 11 petition. Here, the claims also relate back to the year 20.
File your reply.
I may be pardon your lordship. Item 22, I'm appearing for the petitioner.
An objection has been filed. You have filed?
I filed in the registry survey copy.
Filed on behalf of the opposite party, resisting the petitioner's application for appointment of arbitrator. Also, a copy of this application has been handed over to learned counsel today.
Today, madam.
Has been handed over to learned counsel for the petitioner today itself. Stop. So as to enable learned counsel for the petitioner to consider this an objection. Does this matter on 2 weeks? 2 weeks.
I may
Item number
pardon.
24.
I may pardon your lordship. I'm appearing for VC, your lordship, item 22.
In 4 weeks time, opposite party number 1, week time to file objection.
And we have the petition.
I am for option number 2 to file. I also like to file objection and then close.
As requested on behalf of the opposite parties, is this matter on? There are how many opposite parties?
There's 1 to 5.
Does this matter on 2 weeks? 2 weeks, so as to enable them to file objections less counter affidavit, if so required. If so required, yes.
Item number 25.
In number 23 weeks time, maybe get for filing objection.
What I claim about running system of an objection, 2 similar matters, in the second round case, Violence had issued the notice and application appointed in 2 similar matters. Only this was left out because the notice had not been sent to the government matters. Other the principal employer had received a notice, and other 2 also, they have received and minors have passed this order matters. My learned sister agrees, the same arbitrator may be.
No, let it come. See, let her seek instructions. Same can be appointed, but
Same matter, matters. Only thing I not only asking to file a better sending notice to the government. Then I send a notice after 2 months I came back. And minors have issued notice and other 2 similar matters, same work matters. If my learned sister agrees, then Minister can be. If she agrees.
no. How
Because
can
only counter rejoinder, everything had been filed in the other 2. And minors.
but in this case, they'll have to file. Or you'll have to seek instructions whether to
Other 2 numbers I give.
make it as requested on behalf of the opposite party. Please list this matter on 2 weeks, 3 weeks.
3 weeks.
So as to enable her to seek instructions. File objection if so required. Yes.
Specialist for hearing, item number 1. CRREV, 88/2000.
My lord, item number 1 and 2. Officers engaged me as the amicus curiae, but my name has not been accepted. So that's why item number 3 and 5, I'm reading. These 2 matters will be taken up next week.
Let all the matters come next week.
Item 4, my lord, sir, may I pray for 2 weeks adjournment? I will collect the LCR. Item 4.
In fact, I wanted from the state government list of that I had supplied, other the court had supplied to the government the list of these criminal revision applications, and we wanted to know whether the persons are alive or not.
Yes, that is to be, because this is amicus curiae, I could not also take in, this occurrence has taken place in 95.
95.
Yes. And one case, that item number 1, just now I was checking, though my name does not appear. That criminal appeal was heard in the year 94 or 95. By then, that person was in custody. While in custody, the appeal was argued, and by then he had undergone for 4 years. The London Appellate Court has recorded, and perhaps 7-year maximum sentence was awarded to him. So I don't know whether he is still there in custody.
I am making an endeavor, my lord, to seek instruction whether this.
Just find out.
Yes, ma'am.
If
Right.